Good evening and welcome to the York County Zoning Board of Appeals. Meeting is called to order. As we have our meeting this evening, we have several items on the agenda, cases. And we'll go through the cases. We ask that you please mute your phone. When we have the different presentations, the applicant for the request will come forward and the staff will give their presentation. The applicant will come forward. Then we'll open it up for a public hearing for those who are speaking in for or against. And when you come up to the podium, please state your name and address for the record. And then we'll have a possible rebuttal, if needed, by the applicant. And then we'll close the public hearing and then open up a motion from the board to accept, deny, or defer the application. Then we'll have a discussion and vote. Okay? So in that case, the first item on the agenda is the adoption of minutes. Is the board taking a chance to look at the minutes?
First of all, Mr. Chairman, I'd like to make a motion to amend the agenda. I would like to take item number 5, which is case Z21-31, and move that before item number 4, which is Z case 21-30. Just switch those two items.
Okay. Second. Have a motion and a second?
Second.
Sorry.
Yes. All in favor? Raise your hand. Okay.
Mr. Chairman, excuse my interruption. I just wanted to say that I wanted to bring up a deferral of item number 4. So first, staff finds that the applicant may have not accurately surveyed all the grand trees, and this is assuming y'all have read your packets and reports, have not surveyed all the grand trees within the proposed limits of disturbance. So to prevent the applicant from inadvertently removing grand trees in violation of the ordinance, or to request an additional variance for previously unidentified grand trees at a later date, we recommend that this variance request be deferred to allow the applicant to submit an updated tree survey and for subsequent staff review. I just wanted to bring this up ahead of time in case I wanted to make that decision before we get there.
Okay, thank you. All right. So we have old business, Terry Rosenberg.
And Mr. Chair, I just wanted to be clear because it's an unusual circumstance. But what staff is requesting is deferral of the entire public hearing for that item and not of the decision. So staff is recommending that the item be deferred to a later date so that the board will have full information. The applicant will have an opportunity to have all of the required details for the grant tree survey requirements.
So that's for case Z21-30.
Correct.
30.
If appropriate, I'll make a motion to defer.
I'll second it.
It sounds like based on what they're telling us, the tree survey is incomplete. So that wouldn't allow us to really make an informed and educated decision on the variance request. I'm not sure we want to, based on that recommendation, put them through that, go through all that without the correct amount of data that staff requires for us to see to be able to make that decision.
So there's only like 9 trees on that list, right?
Question for council. Does applicant have to request that deferment? Or can staff make that deferment on, or request for deferment?
Typically, that request is made by the applicant, since staff is the one requesting this deferral, and they've brought that up now. If you all would want to consider that, I would suggest giving the applicant an opportunity to come forward and speak as to the deferral.
If we wanted to go ahead and do that, would we need to move that case to the front of the line and let the applicant come forward? If we wanted to make a decision on it now?
You could go ahead and do that right now if the applicant's ready to come forward and discuss deferral.
Okay, thank you.
So should I ask, is the applicant here? Chad Goddard?
most of us are here, but we would be against deferring it. We feel as though we have all the information in the packet and it is before you. So we do not agree with the assessment by staff. Grand trees have been surveyed and provided in the packet, if that's the request for the deferral. I'm sorry, Kelly Clayton with Lightner, project manager for Indigo Rush.
And your address?
312 Pendleton Street, Rockville.
So how do we proceed then from that?
I have a question for staff. What time frame are you looking at a deferral? 30 days, 60 days, or, I'm sorry, like August meeting, September meeting?
Yeah, we would say to a date certain to the next meeting, so the August meeting.
August meeting.
That's correct.
I got another question for staff. Okay, on, relevant to this, on page 5 of their portion, 1, 2, 3, 4, 5, 6. It looks like 7 trees. Is that all? Is that why? Because they're asking for 39 and you only got 7 listed here? Is there a list in here that I missed?
We provided a list.
We don't have it. That's what I'm getting at.
Mr. Chair, at this time, I mean, you've heard staff's position on this, you've heard from the applicant. The board doesn't need to make a decision now. You can take this up when you call their case later tonight.
Okay, thank you.
Okay.
Do we need to take the?
We have a motion.
Second off the table?
We still have to vote on it.
Yeah.
But this deferral does not, if we hear the case and we decide to defer it, if we defer it now, that doesn't change if we decide to after we hear it and with a public hearing, is it? Does that have any bearing on it?
So I believe we were requesting to defer the entire public hearing. If you want the applicant to go ahead and you want staff to do their presentation and the applicant to do their presentation, we can go ahead and do that. And then if y'all want to, at that time, defer making a decision, that's also an option as well. So approval, denial, or deferment.
Okay.
So I just wanted to present that because you all know this is a pretty lengthy report and we have a sort of heavy agenda. So I just wanted to make that clear, given that is our first, what we would prefer.
Okay, thank you, I appreciate that.
Okay, we'll take it up when we bring up the case.
Okay, so no
Yeah.
motion.
Well, we've got.
Other than
We got to vote.
moving
We
the
started
case
voting
to the
down.
back of the case on crack.
We had a motion to defer the case
And a second.
So we at least have to vote on it.
and discussion.
I mean, the applicant's here and says he's ready, so I think we at least ought to get the decency to hear him out. So.
I'm in agreement.
I agree.
Okay.
Any further discussion? Motion to defer. If you agree, raise your right hand. If you disagree, raise your right hand. Okay. Okay. All right. Moving ahead then. First case this evening, Z21.
Mr. Chair,
They do the minutes.
We have to do the minutes.
I got interrupted. Okay.
Make a,
Motion to approve the minutes as written.
Second. All in favor of approving? Thank you. All right. All right. Is staff ready to present the first case?
Our first case for tonight is old business. Mr. Terry Roseborough's case. He's at 624 Rivercrest Road in Rock Hill. And the zoning is RUD, and he's requesting a road frontage variance of 100 feet. Just a quick recap. It's the zoning map here, RUD, the aerial map. And then I put them side by side just for you, Derek, to give you the comparison.
Thank you.
You're welcome. The one on the left can be administratively approved by staff. The one on the right is what Mr. Roseborough prefers. And then for the reason why it's old business is the first deferral was so the applicant could have time to explore administrative options with staff. And then last month's deferral was because Mr. Roseborough's work schedule would not allow him to be here. So, let me take this off here. And then the approval criteria have not changed. We decided he did not meet the criteria for A, and therefore he did not meet the criteria for B. He did not meet the criteria for C, but he does meet the criteria for D. It would not cause a substantial detriment to the public good or adjacent property. And you have a memo in your packet of what has happened since we have talked about Mr. Roseborough's case. I believe Mr. Roseborough would like to have a decision so he can move forward instead of a deferral. I will move it back to, oh, and we did have some conditions if you decide to approve. We do recommend denial since he doesn't meet all four. If you recommend approval, we recommend a condition be a new lot must have legal easement to Rivercrest, and it would be, the variance would be null and void if the resulting lots are further subdivided. And I'll go back to Mr. Williams' favorite slide.
I do have a question. And part of it's just to bring my memory back from when we heard it the first time. So tract B is going to remain the same, nothing changes. That's 1 acre. Lot A, which is different based on whether, what is he's asking for, the variance, and what you said does not require a variance. That's less than an acre?
It will remain an acre, above an acre
Okay.
in either case.
Okay, so and that has an existing house on it, correct?
Yes,
And so lot C is the one that he wants to build the house, or tract C is the one he wants to build the house.
yes, ma'am.
And then what is the acreage on that one? Is it the 4.14 or is it smaller than that?
It's 4.14.
Okay. Thank you, that clarifies it.
Is it 4.14 with the administrative
variance
approval?
No, it'll be
Okay, so
slightly, yeah,
The variance requirement is 4.14,
yes,
so it'll be slightly larger.
yes.
Yeah, because I was confused on the site description. So one contains 0.37 acres. Is that before he subdivides it?
There is a little tiny lot
Okay,
against the far left of the plat.
gotcha,
that
okay.
is recombined in. So you can see
Okay.
the numbers are changed.
That was where my confusion was. Thank you.
Any further questions for staff?
Okay.
Thank you.
Okay, no, I do have another question. So on his application, he says the lot I want to build my new house on is 1.5 acres. No, it's really 4.1, right?
Yes, it
Okay.
was, there's been some changes.
Okay, that's added to my confusion too, so, all right.
All right, thank you. Is Mr. Roseborough here?
Oh, he's not here.
And we've already had public hearings. We don't have the public hearing now, right?
Well, the public hearing has already been had, so the deferment was for the decision. So y'all can render a decision tonight, and based on previous correspondence, and Marion alluded to that, Mr. Roseborough would prefer, even in his absence, if y'all would go ahead and make a decision, so that way he can figure out what he wants to do either way, depending on your decision.
Okay. So we need a motion from the board?
To deny?
I'll second.
All right, motion to deny and a second.
I've been trying to rack my brain about this because it's been so long. But I never could get a clear answer as to why he needed it. The one on the right. Why the one on the left wouldn't work. Something about a garden. I mean, I never did follow. And so if it can be done, by right, then why do we need to be passing out a variance for that?
Correct. Plus it has road frontage,
Right.
especially for future generations and,
I just think it's a cleaner way is the right, or the left, excuse me. So that's my decision.
Okay. Any additional?
Same difference if he wanted to, if he's trying to split up the 4 later on. Be the same here, he still has to come for a variance. So all these conditions would have to be recorded. Oh, you gotta tell me, just wait at me, Agent. Sorry about that. All these, contingencies, gotta do this, gotta do that, wouldn't have to be recorded with the property. Go back through the regular channels, he wanted to try and split it again.
I mean, I get it. If we weren't talking about a variance, or if the road frontage was an issue, the option he prefers on the right is cleaner. For the one outlined in blue especially, it's, you don't have, this odd piece of kind of property that you don't control in front of your house, and I'm assuming that's a driveway that's there that's gonna remain, and it's cleaner. But there's an avenue to resolve this without coming here.
Correct.
And I think that is the way it should go, rather than what might be cleaner, and just my thought.
Any further discussion? We have a motion to deny the request, the variance. All in favor of the denial, raise your right hand. All right. All right, next case, C21-23.
And this case also came from the May meeting. It was deferred for 2 months. I'll give you a quick recap. Applicant is Corey Goldstein. The property location is 490 Rowells Road, which is in the southeast section of this county. And it's zoned RUD, and they're requesting a curb cut variance. You have the zoning map here. Just a quick recap. You can see the aerials right there. The paper factory is located directly to the right there. Give you a location. Here's the existing conditions and the proposed subdivision. And I circled the curb cut up at the front because that is the location of the problem here. The yellow is the proposed encroachment onto Rowells Road, and the butterscotch is the encroachment of the neighboring mobile home park. The applicant was given 2 tasks by the ZBA. The first one was to notify the neighbors of the proposed development, and the second one was to research with the SCDOT about the curb cut encroachment, the butterscotch section there, for the neighboring mobile home park. And I also have an aerial kind of giving you a better idea. You have 3 driveways kind of there in the middle. The bottom driveway is for the mobile home park. The middle driveway is going to be proposed road access back to the subdivision, and then the next driveway up is for a single-family home. So we are concerned with the curb cut separation between the mobile home and the proposed access for the subdivision. The house on the right, the last I heard, had currently agreed to access from their home from the new road instead of Rowells Road. Again, this is an older case. Our approval variance, our criteria have not changed. It did not meet A or B, and then it also does not meet C or D. So we did recommend denial since it did not meet any of the 4 standards. But we also had conditions on approval that adjacent lots to Empyrean Way shall be provided access to the new road, even if they do not want to access it. They should be provided. And go back to, which one would y'all prefer?
That one. Oh, the one with the butterscotch, because I have a question.
Yes, ma'am.
So what was the findings? Was that driveway obtained through legal means?
The applicant is here.
Okay, gotcha.
I have a question for staff, and I may have asked this last time, I cannot remember. Does it still have to go to planning commission when it leaves here? If we approve this, if we approve the curb cut, does it still have to go to planning commission?
Yes.
Thank you.
We have to have this approved. This is the last step before I can go to planning commission.
Any questions from the board?
Well, I have one. Last time they were here, there was a lot of discussion about the entry to the road from the trailer park.
Yes, sir.
So would the applicant need, if we have questions regarding, I think that might have been what you were alluding to, so we would need to ask the applicant those questions?
Yes, sir.
Okay?
Oh, I do have a question for staff. So, in the letter from DOT, the DOT asks that if it's approved, that we stub out an access point to each property so that if either property is redeveloped in the future, they will have access to the stub location.
That's the neighboring properties along the driveway.
Right, so if we were to approve it, would you consider that a condition?
That is the condition.
Oh, is that the condition? Okay. All right. Sorry about that. I must have missed that.
Thank you. Would the applicant please come forward?
Hello again, everybody. My name is Corey Goldstein, and this is my business partner, Ben Gaben. And for the record, Corey Goldstein, 168 Highway 274, number 309, Lake Riley, South Carolina, 29710. And by now, you probably guessed I'm not from here. And in the short time that I've been here, I've come to love South Carolina. And once you get past perhaps my northern, oftentimes rude, abrasive way, hopefully you'll get to love me too. And just to recap, if I may, tonight really is a paramount question for us because it really judges whether we can move forward or not with the 16-home subdivision or simply have a single-family home on 21 acres. You had approved a motion for a 60-day continuance that advised us to study and get clear on all the facts of our adjacent neighbor's driveway. If you'd like me to address those issues or stick to focusing on the items A, B, and C, and D, I'm happy to do that as well. You had also asked us to communicate with the surrounding neighbors and property owners about our development, to offer them an opportunity to share, express their concerns, etc. And at this time, I'd like to introduce Ben Gaben to address the results of that community outreach. That be appropriate?
Yes.
Thank you.
Hi, my name is Ben Gaben, 75 Stonebridge Drive, Asheville currently. I'm in charge of community outreach for this project. And I have a few... Oh, okay. All good. Thanks. So the recommendation from the board 2 months ago was to reach out to the neighbors and basically include them as much as we could in the development process. There are 13 parcels that are adjacent to ours. We went ahead and mailed certified letters out to 21 of the surrounding neighbors. Here I have the UPS certified mail receipts and tracking numbers. And then again, evidence of the letters. So this is an example of the letter that we sent. As you can see, we created 2 different live Zoom calls for the neighbors to participate in. We wanted to be able to accommodate their schedules. We also provided our personal contact information should they want to reach out to us. That's my phone number and email. And of the 21 letters that we sent, we had 3 neighbors reach out. One of them called me on the phone. Her name is Ms. Lansdowne. She lives on the opposite side of the house. And her concern was whether or not our development meant that she would have to sell her mobile home. I assured her that no, that's not the case. We had a lengthy conversation. She ended up saying that she feels quite lonely where she is and she'd like us to develop. She's looking for nice neighbors. So that was what Ms. Lansdowne had to say. I wrote her a thank you email just following up, and she replied that I can call her Shirley. That was nice. This is the first Zoom call. We had two different neighbors join the call. Up here on the right, you can see Tony Crane. Her name is actually Miss Adams now, which I learned on the call. So she was on, and Miss Brown was on as well. As you can see, Miss Brown isn't adjacent, but she is one of the neighbors that we reached out to. And, you know, really, the call was for listening and getting the concerns of the neighbors. And the main thing that they communicated was that they don't want to be burdened by another subpar building in the neighborhood. There's an abandoned nursing home about a block from Miss Adams' house. It's a tax delinquent property. And then right next to our property is the dilapidated trailer park. They don't want to see a repeat of this, which we totally understand. I took the concerns back to the team and shared and came back to the second Zoom call, ready to share that in no way would we ever create something like this. And Miss Adams, who said she'd be on, wasn't on, which is probably good news. But she did call the contract seller of our property, Mr. Peter Perrell, who's a retired Rock Hill attorney local to this area. Prior business partner, master in equity court, Judge Jack Kimball. Mr. Perrell is actually available now via Zoom if we'd like to reach out to him, but he ended up sending a letter to the board tonight. You know, if you haven't read it yet, I'll summarize. He says, this is who I am. I'm involved with this 20 plus acres on Rouse Road, having sold it to Corey Goldstein. I've worked with Goldstein on several other projects and find him to be the most knowledgeable, experienced, and trustworthy person I've ever worked with. This letter is to offer my wholehearted endorsement for him and his team in developing the Rouse Road project. His plans will enhance the area with a well thought out housing development of upscale homes. It will greatly increase property values around it and further the county's efforts to improve this area. He has a professional team of experts and can be depended on to provide a highly desirable living area for 15 or so families. I can see no negatives to the area in his plan. The road was one I freely gave an easement over to owner Canty, who had no legitimate access to his property joining this. If allowed by the county, this road would be upgraded to better serve property owners using this access way. In recommending Mr. Goldstein, I have no reservations about ensuring the board of his future efforts improving the Rouse Road area. Thank you. That's a letter from Mr. Perrell, and we actually, since it was on Zoom, I was able to record the meetings. If I sent these to the county staff, and if anybody wants to see what happened on the meetings, that's the link and the password. Nobody showed up to the second Zoom meeting. So, Mr. Goldstein, back to you.
Thank you. We also obtained a endorsement letter from Mr. Gaskin. I don't know if you could put Mr. Gaskin or that. Why don't you do that? Because I'm going to screw that up. Thanks. Mr. Gaskin, this was his letter. This gentleman's been living there for many years. His home is actually right in front of the entrance. If maybe you can go to the next slide. To the property. And you can see where William Gaskin is. Gaskin, William, Adam. His property is close to you can see where it's at. And so we consider his endorsement the most critical one because his property will be impacted with theoretically, earth moving equipment, et cetera. And so he supports this. And the zoning board's vote for an extension really focused on the request of establishing if the trailer park's curb cut was permitted or not. That was the task you charged us with. You and specifically were like, you need to get this, and thank you for the extension. Truthfully, I didn't appreciate the value of that. I do today, because we got an opportunity to learn a great deal. So we actually contacted Mr. Dave Gamble, who I believe that you know. He's the District 4 permit engineer. And upon his initial investigation, his initial review, he found that no permits had suggested that, and no permits, and he has suggested that we do a deeper dive. And so we did just that. We did a deeper dive into the SCDOT archives. And we worked with Miss Shirley Anderson, the FOIA manager at SCDOT, and we made a comprehensive look back in time. And the request was, if at any time in the past, searching all records of all current or previous owners, if they've ever made a submission, ever made a request, ever made any paperwork that was filed, created any engineering plans, paid any fees for the right to access Rowles Road, and here's what they came back with. So the SCDOT, that's on you, not me. The SCDOT began tracking information in 1958. And so our request could only go back to that period of time. And at no time since the SCDOT began have there been any recorded permits, nor had any person or entity ever applied for or obtained any permit whatsoever of any kind to clear land, install roads, driveways, or have any kind of legally permissible access road for homes or trailers to Rowles Road. And we've submitted in our process over these last 2 years, we've submitted engineering plans to the SCDOT, the ZBA, to provide a safe and secure road for the few families that'll actually be living at the property and using this road daily. And when I mean few, I mean the addition of the properties we're speaking of will have a net impact of 1.25% increase in traffic volume, a total of 517 cars per day. And this area, based upon the traffic impact study, currently has will have, with this addition, a 4.48% utilization of the road. This aspect of Rowles Road can handle 11,524 cars per day. Will be at 517. So its traffic, thankfully, won't be an issue. Ben?
So, thank you to the staff who's partnered with us, and they made it very clear that the decision for the variance rests on the 4 variance points being complied with. Given the work we've completed over the last 60 days and a recent update, we'd like to brief the board on that. Is that appropriate? Thank you. And have my business partner, Eric, pass out some recent information.
Yes, please.
Thank you. Ms. Ray, yeah, please, that'd be awesome. If you could start on letter A, that'd be great.
Thank you.
As we're pulling the slide up, the first few pages are the review of our preliminary plat. You can see how close we are. Awesome, perfect. So the county said that for letter A, we actually do meet the criteria, which it says up there. And we agree with that, and we feel that something very important was left out. And if you could please flip to page 5 of your packet, you can see all of the water issues around the surrounding area. When we initially went to the county to develop our lot, they showed us this GIS image, which looks kind of scary with all these waterways going through the different properties. And we were told that we would have to work with the Army Corps of Engineers and have them file a jurisdictional determination, which if you've developed anything before, you know that can severely hinder a project. We hired a wetlands specialist, scientist, to come out and survey the property. He wrote a letter determining that there were no wetlands on the property. The Army Corps went out of its way to actually visit the property and confirm the finding that there were no wetlands on the property. The whole process took us more than a year to complete. It was a very cumbersome process, and we really dodged a bullet. If you look at the next page in the packet, this is the letter from Mr. Schwartz, engineer in the U.S. Army Corps, saying that as far as they're concerned, nothing else is needed. The signature is on page 7. And on page 8, this is an email from Mr. Jeff Smith from the county. He said, Ben, after speaking with Jonathan Schwartz from the U.S. Army Corps of Engineers, nothing further from the U.S. Army Corps of Engineers will be required for the proposed Moore subdivision. So fortunately, we were able to bypass this. But, you know, when you look at that map on page 4, you can see the issues that other properties may run into, which we feel like sheds light on how extraordinary this property is, given that we've been given the green light from the Army Corps. Secondly, the fact that we were given 2 extra months to determine if the driveway next to us for the trailer park was permitted or not, and to include our neighbors in the development process, we feel also sheds light on how exceptional the conditions actually are here. So I'm going to let Mr. Goldstein come up to address letters B, C, and D.
Okay. Thank you for allowing this tag team. In B, we have that these conditions do not generally apply to other property in the vicinity. So as we had previously evaluated, viewed, and studied each property that the county selected to compare ours, we visited them, we took photos, we did on-the-ground inspections, we made detailed notes on each parcel, and we found that properties that the county selected were not comparable at all. And we reviewed these in detail last time, and I brought the comps here if we'd like to spend some time and look at them. I'm just kidding, this is an empty box, but I thought it would be funny. There were 47 parcels in the area, of which 2 parcels were the parcels that the county selected. Parcel 1 was a 8.96 acre property with 62 feet of frontage. Perhaps we can put that up.
That's located in the packet.
Okay. Oh, thank you. I had an opportunity to speak. Oh, thanks. I had an opportunity to speak with Ira Hovis, who's the property owner. He has no interest whatsoever because he says his property gets water all the time, and the probability of that being changed is 0, and he has no interest in that. The second parcel is a 91 foot has 91 feet of, I guess if you could call it frontage. It actually backs to Rowell's Road. It doesn't front Rowell's Road. And it's actually split in 2 separate parcels. The total acreage is 0.8 of an acre. And if you can take a look at, that's the property on Clemens Road. It has a road going through the entire property. So these are not comparable properties whatsoever. The 2 properties are completely different. And we believe that the Clemens Road, if that had a problem, couldn't even be rebuilt. And with the severe problems of the other property and the extreme water issue, our property clearly is uniquely different. We've addressed any water issues, resolved the errors on the GIS mapping problems. We've obtained letters from the Army Corps of Engineers and been approved by the county for all other issues associated with this property other than this variance. Because of these conditions, so point 3, because of these conditions, the application of this chapter to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. The county says the lot has grandfathered access onto Rowell's Road and can be used as a single-family lot. In addition, the neighboring driveway placement was mitigated previously. Additional efforts to come to an agreement with the new property owners could remove the necessity of the curb cut variance. Staff found the variance does not meet the criteria. The central point here is that the county did a review of the plat, and we were allowed use as a subdivision. The disparity between one single-family residence serving 4 or 5 people on a 21-acre lot versus 16 residential lots serving 72 people or more is substantial. It relates to land use. This is an allowed use. It's permitted use and by right RUD. Section C addresses utilization. This is a real question here. Utilization is defined as the amount of something available compared with the total amount that could be produced. This property would be severely underutilized. There is a significant and clear hardship. Now, with all that being said, we've actually done the work to come to an agreement with the trailer park owner. We've agreed to terms with the adjacent property owner, and our attorney is drafting documents for final signature. The undue hardship is going, hopefully, away from one single-family home to 16, and we're asking for and the point would be, that I would say, is no person interested in a single-family home on 21 acres would want a public street. And that we applied for a subdivision with the county, and we weren't denied at the time of application, is a key indication that we're on the right track here. And so they would have thrown us out a long time ago. So please, don't tell me that we can have a single-family home here. Point D. The authorization of a variance will not be of substantial detriment to adjacent property or to the public good, and the character will not be harmed by the granting of this variance. The county says the variance will be of substantial detriment to any adjacent property as a proposed curb cut for a proposed 16-lot neighborhood will restrict the usage of the current curb cut for the adjacent property owner with 6 existing homes, trailers on their lot. As such, a proximity of 2 access points on Rawls Road will be detrimental to the usage of the road by granting of the requested variance. The staff finds the proposed variance does not meet this criteria. The character of an RUD, the very fabric and nature of the character of RUD, it's experienced at the road level. Large lots, large single-family homes, and the experience is space, open space. That will not change, not whatsoever. This point speaks to the character and the environment and general means which are architectural in nature. In this case, our property sits back well over 500 feet off the street and will not change the visual experience of the RUD zoning. Nobody's going to drive down the road and experience anything different, no disruption whatsoever. Aside from the environment we're creating, which is a safer environment, by cleaning up this intersection. And as I said, as it relates to traffic, the current design capacity is well underutilized. So for that reason, we request the approval, and prior to that, happy to answer any questions that you've got about what we've done to get to this place by taking on your recommendations. Thank you for all of that.
Mr. Goldstein, looks like you've done a thorough job. You said your attorney is working on an agreement with the owner of the trailer park.
We have an agreement.
You have the agreement. And does that agreement include a condition of using the new road and demolishing the existing curb cut that's there?
Yes. Yes. Oh, Ben, you want to speak to that? Okay.
Would you mind repeating the question, please?
Does your agreement include demolition of the existing curb cut that they use and
Yes.
then to use the new road?
Exactly, yes.
Okay.
And they have a curb cut more than 250 feet away.
Well, hang on a minute now, because that's my question too. In the letter from David Gamble, it's the only thing we got in our package, he says that in order for you to do it, you need to have both adjacent properties going into one driveway is the way I'm reading this. Is that gonna happen and you got proof of that? Because he's saying he's not gonna approve it if you don't do that.
This is the variance request.
Right, so what are we down to now? That's what I'm getting at.
Right.
Where are we now? We're gonna have two driveways, one what?
No,
Are the adjacent property owners gonna be, it says if the adjacent properties do not agree to closing their current curb cuts, drives as part of this project, the department will ask you to stub out an access point to each property. Do y'all have an agreement to do that?
we have an agreement with the trailer park owners.
But the question now is the owner of the home on the other side
Yeah,
of the
it's still double.
driveway.
Clear, thank you. I just needed to have this so I can reference.
I'm going by what Mr. Gamble at FCDOT told you as well.
Yes. So during this past 6 days, the agreement that we had with the house, which is 60 feet away from our road, he's decided to sell his property.
So you don't have an agreement with him,
No longer have the
but
agreement.
you got an agreement with Peter on his old trailer park, right?
I beg your pardon?
You got an agreement with Peter on the old trailer park.
Well, with a different company,
Yeah.
Peters, yes.
Yeah. I know him real well. But the guy in the house on the right don't, we were talking about, he could come into the road and then go out on the Rowell Road. That didn't happen.
That's correct, he's
Okay.
changed his mind. And so this is the very reason that we're in front of the board, which is to have this variance, to be able to have the confidence and the certainty to be able to move forward in time to really create a future protection so we can think forward. If zoning changes in this area, if something else changes, we are subject to like a leaf on the wind. It becomes a real problem. And it future protects us from potential highway changes and state changes and any potential zoning regulations. And so this is the reason why we're here, and unfortunately that happened in this short period of time. And now we've danced with one major issue, which was 14 feet away. We were 14 feet away, now closing that off. So now we're 60 feet away.
So the question I have, I think what would have helped us significantly, the owner of the trailer park, since that was a real sticking point in one of the conditions, if either they were here tonight or provided a letter stating that we've agreed in principle, but
We have
there's
that.
a contract pending.
We have that.
Okay.
Yeah, we'll have
That's
to
what
pass
I'm
that out.
saying, yeah.
But now,
But now there's
Now-
an
now
issue on the
also
other
the side.
side.
Yeah.
Yeah.
Was there an offer made to that owner because one effort to eliminate and secure your position could have been, well, we'll buy it. Because if we own it, now that's ours, we control that driveway.
We've done that.
And was any traction made there? Or it was
we
not?
were a little in the mud. We were a little in the mud with that. It was a real disappointment after all that time,
So he rejected your offer.
Yeah.
Well, yes, he made some other decision after
Okay.
making an agreement. So this is the very thing that we're requesting, is that you can see that we've been back and forth several times. By solving this one issue, we're actually able to now make a request. It's the same request. It's a modification to distance.
What about the third property, Mr. Workman's property? That's,
Mr. Workman?
or is that, who's the owner of the one that's directly across the street?
Oh, Mr. Gasket. Oh, that's fine.
It's Workman on here, isn't it?
Oh, across the street.
Cross Rawls,
North of Rouse Road?
yes,
He's in fine standing.
okay.
There's nothing there. We've communicated with all the neighbors for your suggestion, and we haven't had any issues at all. Other than, a couple of people that were on the Zoom call. We're only as good as our contracts and agreements, and those are really great. It's the intention behind it all. we've seen in this transaction that I've experienced with just a couple of people. Say one thing, do something else. And we're not interested in, we're interested in honoring things. We're just interested in honoring an agreement, coming up with that, and solving our issues regarding this. And we really want to, by granting this, we remove that concern. We remove the concern once and for all, and we don't have to look back over our shoulders to try to create something else out of this property. Thank you.
Any further questions? No? Thank you. So we have motion from the board.
Is there any,
Didn't we already have the public hearing?
yeah, we did,
We haven't had that. Oh, I guess we did at the previous.
we did.
Yeah, if we already had a public hearing for this. Right?
You did, Mr. Chair, and that's at your discretion if you just want to ask if there's anyone
Okay.
here who wants to speak.
Okay.
I think, I mean, it's up to you, but we sent them home to talk to the neighbors, so let's see if they talk to the neighbors.
Okay. All right. So is anyone here to speak in favor of the variance request? Anyone here to speak against the variance request?
Chairman, I will say that our department did receive 2 emails from some folks who were in opposition but unable to attend the hearing tonight. We encouraged them to come, but they weren't able to. And one of them wanted you to know, and I'll read you what he says. He says, I want the chairman to know that the group that planned to build and the others are planning to build trailers or campers on the land. Can you pass that information on to them? They paid one of our neighbors $500 to say he was for the development. And we received one other. Do you know where the other one was? And then we received another email. This one is a little bit more lengthy, but in closing, he says, many neighbors, including myself, do not trust this group of people running this project. I am not the only one that has experienced their dirty business practices. So I will say that we did hear from 2 neighbors who were in opposition that were not able to be here tonight.
And you didn't send forward those to us, right?
No, those were not forwarded to the board. We received them earlier in the week. The public hearing had already happened. That was why we didn't, but we thought it was better safe than sorry to bring them up tonight. So my apologies.
Okay. Hearing that, do you have a rebuttal for the emails that were submitted?
I do, thank you. So I received a phone call from Peter Perrell today. Peter is a personal friend, prior business partner of a pretty well-known judge here locally. I'm friends with the family. We've known each other forever. He received a phone call about when was the Zoom call? Maybe 2 weeks ago from Miss Toni Crane, the neighbor, and making a variety of accusations about me personally. Mr. Perrell dispelled, and he said whatever he said to her. I went to Miss Toni Adams maybe 2 years ago to have a conversation, haven't spoken with her since. And I am saddened by that, and I get people do whatever they do, and that could potentially impact some decision by the board, and my request would be, if the board is going to take a vote, that it considers an extension such that I can make a request of Mr. Perrell to come down here He's actually on watching this right now to address this issue. And so he can speak to you about the conversation that he had with her, because I believe that this is what's going on here. And regardless of how much money I've invested in this, that's nobody else's consideration or concern or how much time. But to intentionally cause and inflict harm without having conversations about coming up with some other solution is just inappropriate. And to be blindsided by this right now, instead of knowing about it, to be able to address it, is inappropriate and insulting that I'm having to actually sit here. I'm embarrassed. I'm embarrassed that I'm having to deal with it now. So.
It's hearsay. It's hearsay.
Clear, still doesn't feel good.
I do have, can we ask him one more question?
Yes.
Right, quickly add on to that.
Regarding the letter, it says here that my clients are willing to pay $15,000, and down at the bottom in the email, it says, we would be happy to agree to abandon the driveway in exchange for $23,500. So when you say there's an agreement, is that spelled out, like what the?
Yeah, no, I understand the question. So the 23 was what they asked for initially.
Okay, I do see 514, and we are agreeable to this proposal subject to adequate review and approval of the actual agreement. Okay.
Could I ask the staff about are you willing to share who wrote those emails?
Nope.
You have to if you FOIA it.
Public record, but is now the time.
Right, it's not the time, but you could get them, yeah.
Okay, great, especially because you saw the letter that I sent to everybody. I made an effort to include everybody, and so to do that is like kind of weird, but on the first Zoom call we had, there was a gentleman who said, I have blueprints of you guys building a trailer park. I said, that's not true. Where did you get that? He said, I'm just joking. And he got off the call. And so if anybody were to view that, you'd see exactly what's happening here.
We may have gone over this the last time, but what is your product? What is the product that
Sure.
y'all are proposing?
Yeah, so our proposal is 16 residential homes. What we're looking at here tonight, this is like the tip of the iceberg. If you guys give us the thumbs up, we'll be able to continue and have that conversation as a team between rising home prices and what's happening at the Indy plant. You know, there's a lot of discussion for us as a team, how we're gonna move forward with this.
Well, you say residential, are they double wide? Are they stick-built houses? What are they?
Exactly what Ben said. We initially were looking at single-family homes, higher-end developments, similar to a couple of homes in the areas, in the 450 to 600 range. And given the current costs that we may have some changes that need to be made. You know,
Well, we're just asking simple questions. They pre-manufactured homes or not?
Single-family homes, I mean, on 1 acre lots, 3,000 square feet, 2-story, market values.
So they're stick-built houses, is what you're
Stick-built
telling me?
homes.
Okay.
Yes.
All right. Thank you. All right, board. We have a motion.
What is the motion? It's been so long.
Well, it's the curb cut variance.
We have a. Oh,
We would
Well, the last,
need a motion to approve or to deny with some stipulations.
did you have did you have some conditions before?
Just the one. There was just one, correct? And that was what we referred to
Okay.
earlier,
Okay.
So,
allowing them access off of the,
but don't we still have, because in this statement, I'm not saying approve or deny, but the issue with the homeowner right now is
Not settled.
we're not settled, so isn't that gonna be a complication? Because even if we approve, they're still gonna run into the DOT issue because there's a new pending owner and they would have to, so would we be allowed to approve with a condition that they ultimately get
It'd probably be
We
up
wouldn't need
to
to have that
DOT.
condition. They'll have to jump that hurdle with the
Would
DOT.
they have to do
Yeah.
that? with DOT?
Right, right.
That's sort of outside our purview.
Megan, if you'll read back through David Gamble's letter, he didn't say that he won't pass it.
No, but
It just says that that's the safest route.
Right,
Okay.
right.
my thing was they presented it to me.
Yes.
They got it approved.
We
by
need
DOT.
a
Really did.
a motion to discuss.
Throw out a motion
Yeah.
so
Oh,
we can
yeah.
at least have a
There you
conversation.
go.
Okay,
Turn it.
I make a motion to approve the request with the conditions, number one, staff has imposed.
I'll second that, so we can talk about it.
Okay.
Very good. We have a motion and a second.
Just quickly, before we jump in, possibly an amendment to that motion, if it's appropriate, and I would need to ask staff, can that requirement include that the existing northern, eastern, I don't have the map in front of me, drive for the mobile home park be removed before they receive final plat approval?
Well, I don't think, they have a contract
Yeah, but
in the works that talks about that.
they do have a contract, but that contract could explode,
Yeah.
go away,
Yeah.
and then the county has no.
But
Unless we
if it was
give
never-
a minimum number, if we say the variance is good for 65 feet and eliminate the abilities for 16 feet, but we need a way to give the county staff something to make sure that that driveway gets eliminated. I don't know the best way to do that, and maybe that's a question for some of them.
Yeah, so we've heard to that, because I thought about that same thing, but I think when we looked at this previously, there were multiple driveways, just wherever anybody kind of decided to drive across, and it seemed like that was the one that most people have used. And we determined that they don't have a permit on record or an application on record. So I'm not, I struggle with making them control a property owner that,
They don't
I
control
don't, I
it.
don't
They can't
think we as a
control.
board can make them do something to the neighbor's property. I think we're
yeah.
getting
Well, I
into.
think that's what that agreement is.
I agree with you. I
And
just
if
don't
that
think we
agreement
can
goes
enforce it.
away, so
Yeah.
do we just use a distance?
Well, I was gonna say, I think that's upon the county to then come back and do whatever enforcement they have to do with a driveway that may or may not have ever been permitted.
But here's a question to your point. If the contract, which they're in essence paying that other person, if that is a part of that contract, that the driveway has to be removed.
Yeah.
Because they're gonna put stipulations on that handover, transfer those funds, if it's gonna hold up their approval of this variance. So in essence, if that agreement, if we put a condition on that contract has to be executed, signed, however we word it, in order for this variance to be approved and in full effect, then they're gonna ensure that that is executed, aren't they?
Not if we grant them a variance with no stipulations.
But that's the stipulation. If the contract, if it has to be in the contract and the contract executed.
I
Or
don't think
signed
I
or
don't think we
agreed
should
upon.
be getting involved with the
Yeah,
contract.
I think we're.
Yeah, we need to, their contract is their contract.
Right.
I'm
We
in
just-
100% agreement with that.
Yep.
How do we make sure that the variance, that if we approve this variance, that there's not a driveway 12 feet away from the one that they're proposing? And right now, the
I think you're-
language in the
I think
motion
you're-
does not do that. How do we do
I think
that?
you're onto something with the distance part. We just need to verify.
What's the next closest driveway? What
Right,
is,
exactly. And so I believe the driveway, if you come out of the new road and turn right up Rouse Road, the
That'd be
driveway
the
on the
next
right
one.
was
The next one.
58 feet.
Yeah.
So why don't we put a 50-foot stipulation on it? And
that works.
But what's the difference?
the
It's
difference
50
is that other
instead of
driveway
12.
is 14 foot from where they want to come out on Rouse
But
Road.
you're still trying to control another piece of property with
That's
this
just a
variance.
different wording.
Well, I mean, but
I mean, to me, I think we either, we grant this or we don't grant this, and
But if we
and then
grant
let the
this
county
now-
deal with the
Right,
driveways
right.
that are
agreed.
illegal, if they're illegal, or non-conforming, whatever.
Agreed, but, I'm looking at it from a safety issue, I think DOT's looking at it from a safety issue. And if we don't, I'm with Mr. Cass, if we don't put some sort of distance on it, there is no guarantee that that driveway goes away. They can come in here and build a road right beside it, and it's a safety issue.
We take away staff's ability to eliminate them doing that, 12 feet apart.
Yeah.
By granting this variance. So we can either, in my head, we can either put a stipulation that protects the county from that, or deny. In good conscience, I can't approve two driveways 12 feet apart,
Yeah.
which is what I would be doing.
Particularly one of them going to 16 houses.
And one of them going to 12
Right.
mobile homes or
12
whatever it
goes
is.
in there.
The engineer in me says we need to combine those, and how do we make that happen?
Yeah. Plus the one that's 60 feet to that would be west.
58.
On Rouse, 58, yeah, exactly, on the map. This guy hadn't agreed, but, you know, I'm just being honest and blunt, is that he's probably putting in a blocking maneuver to keep a trailer park being put in mind. And that was my question about these stick-built houses. Because if they're stick-built houses, they're not gonna hurt his value. If they're mobile homes, they will.
Well, I mean, but you know, I kind of, it's on RUD. You can,
Yeah.
it
You
doesn't
do
matter
it.
what you want to put in there. I mean, we're looking
Yeah.
at a road that's gonna handle according to traffic survey, traffic impact and all that. You know, that was not my focal point was what they were putting in there. I understand that, you know, as far as being neighbors concerned, but, you know, that's the zoning district they live in, so.
Yeah. Well, that's what they couldn't get, there's no reason that guy shouldn't put that cut across into that one driveway. Then you've got the 58 is eliminated. That would,
That
help a lot.
makes it clean, but, you know, at the end of the day, how long do you try to put a square peg in a round hole?
you never know.
So. another
Well,
point
is
you
our
need to
only
look at.
other alternative defer until you come back with an agreement showing you're going to remove that driveway or their executed contract?
I think.
My concern is who knows they honor that agreement.
Right, yes, I think
Not particularly them, but the folks that own the trailer park.
if you put a distance in there,
You're covered.
you're
covered.
And that we're not infringing on the neighbor's rights. We're to allow this road to go in here, it's gotta be 50 foot from another curb cut, so. Would you?
And how that happens,
Legal
it's not up to us.
That's
Whether
right,
there's an
that's
agreement,
right.
whether it's just,
So would you amend your motion?
I would amend, I see where you're going with it now. Okay, I'll amend the motion to, two recommendations. Number one is the staff recommendation that all adjacent lots to Empyrean Way shall be provided access to the new road, and that the new road shall not be within 50 feet of an adjacent road,
Another curb
of
cut?
another curb cut.
That,
You want to say?
engineer, does that
58?
work?
Curb cut works, yes.
I'd say 50 because of how accurate is this?
Well, we said 50.
Well, yeah, that says it's 58, so I figure we give them a little bit of leeway there in case something's different, so.
You
if
can
you
say
go-
100, which makes them have to work with that neighbor with the driveway. I mean, that's kind of us, but
I just said 50.
I hear you.
All right.
But what about the house across the street?
That's, well, and we need to specify
Because
the
that's,
curb cut on, I don't have
it's Rowell's Road.
I know, but
Same-
what side of the road?
It's, well, as you're
Well, the same side.
egressing, it's on the left.
So on their side of the road, on the,
It's
the
across from the
west,
trailer.
is it the west side of Browse Road?
Where's my,
You gotta,
I'm looking for
east.
my compass.
It's actually southeast.
east,
That'd be considered
staff says
adjacent,
east, we'll go with east.
Okay.
that'd be considered adjacent properties.
Yes.
I mean, it's one of the curb cuts that,
Yeah,
there's
but I
three
mean,
curb cuts that are,
I know.
You can't, if they're on this side of the road, they have access to a new road that they're gonna build through here.
Right.
We can't do anything about the ones on the other side of the road. So we need, your motion needs to say on the same side of the road as what Empyrean.
Proposed development.
Empyrean Way.
being specific, ultra specific. Yeah.
Or adjoining
Come on,
property.
I was seconding it.
Clear as mud.
Okay, point one. Point two would be, help me, I forgot what
It
I,
cannot, it can't be within 50 foot of a curb cut
On the east,
on the eastern side of Rouse Road,
Which would be the same side.
Same.
AKA same.
Yeah.
You say that and then I'll second it again.
Got it.
You got it?
Yeah,
Okay.
got it.
I'll amend my second to reflect those changes.
Did you second it?
Yeah, yes, I'm sorry.
So we have a motion to approve the variance with the two conditions that were stated.
Yes.
All right, discussion. No discussion? All in favor of the motion, raise your right hand. Thank you.
Go meet the neighbors.
We worked through it.
All right, now we get into new business.
Which one are we on? 5-1?
Case Z2127. 5.1.
Okay.
You want to use his,
I'm sorry?
do you want his packet? I think he's,
Sure.
Right, first order of new business tonight is case number Z21-27.
Neither mind.
This is a variance request for Neil Mitchell at the Mitchell Site Development LLC. Property is at 2029 Filbert Highway. It's zoned RC1 and they are requesting a minimum width road frontage variance. They're actually requesting 2 road frontage variances due to the nature of the property. We have the zoning map here. This is just north of us here in York. And when you see the aerial here, the rear of the property was used by Metrolina Greenhouses and was previously Stacy's Nursery. The existing greenhouses there are not in use and have not been used for more than 6 months. So their grandfathered use of a commercial use in RC1 has been expired. To reopen those greenhouses today for commercial use would require rezoning. And we have the entire lot here outlined in blue. They are proposing to divide the red lot out. It's the house to the north here. They want to divide it out from the parent parcel, and they're going to sell it to the current occupant who is renting the home. The green marking to the north there is the existing easement for those 2 properties at the rear. They're both owned by members of the Stacy family, and that is their driveway across the northern end of that lot there in red. So Filbert Highway, what they front on, requires 350 feet of road frontage. The new lot, proposed lot 1, would have 307.31 feet, requiring a variance of 42.69 feet. And then the remainder lot, the residual there in blue, would have a road frontage of 119 feet, 119.93 feet, requiring a variance of 230 feet, 0.07. So I can go through the criteria here. For A, the subject parcel is non-conforming. It contains 2 homes on a single lot in addition to historically commercial use. So the staff finds that the proposed variance meets the criteria of extraordinary and exceptional. For B, while there are a variety of residential, agricultural, and commercial zones in that area, the uses of those properties appear to be compliant with the respective zoning designations. So staff finds that this property doesn't, the conditions of this property do meet the criteria of do not apply to other properties. It's a very unusual piece of property. And for C, this lot is the current location of 2 homes in addition to the green homes. The existing home the applicant wishes to subdivide from the parent parcel is a grandfathered use of having 2 homes. However, having those 2 homes, that makes it non-conforming, which means they won't be able to build any accessory structures or garages or additions to those homes. So dividing out the land, creating lot for one home and another lot for the other home, would actually create a more conforming nature of these lots and let people use their homes as they wish. So we find it does meet this criteria. And we also found that for D, the variance will not be of a substantial detriment to any adjacent properties. The homes already exist. The greenhouses, again, are defunct. They cannot use them. They are no longer grandfathered use. At this time, they are sitting vacant, and they will continue to unless they rezone to use them for commercial use. They could use them for personal use. That's a lot of greenhouse, but. So the staff recommends approval. It does meet all 4 criteria. So we recommend approval of 42.69 and 230.07 foot road frontage variance requests. We do have 3 conditions, and they are fairly standard conditions. Number 1, the division of the lot be in substantial conformance with the proposed plat. Number 2, the utilities, well and septic shall be provided for each of the lots and shall be entirely contained on each of the lots. So each lot will have all wells and septic systems on the individual lots. And number 3, access easement along the north side, that was in green on the plat I showed you, shall be recorded and shall remain in perpetuity for ingress and egress for the existing 2 lots, the Stacy-owned family from the parent parcel. I'll go back to the plat.
Okay, I have a question. I don't know if this is for you or maybe the applicant. The last condition was the green access point.
Yes, the green here at the top of the plat
Right.
is current access easement. It is currently a deeded easement for
But are
the
we
2
not,
properties in the rear.
are these 2 properties in the rear still landlocked? Because we're not
Yes.
showing any
They are
easement on the blue parcel.
Yeah, it was a kind of a cleaned up plat in order to submit for the variance. So they do have deeded access across the blue lot.
Okay, so it has to be for both.
I'm sorry?
In order, the 3rd point should state that the easement needs to cross both the blue and the red piece of property.
Yes, sir.
Okay.
But it is existing across both the red and the blue. It's just cleaned up right now.
Correct.
The,
Yes.
the plat shows it all the way to the rear.
Yes.
Okay.
It's there.
It's going all the way.
It would have been more accurate to run that green line all the way to back.
Yeah.
Yes. It doesn't conform completely, the easement all the way to the back. It does follow like an old driveway. So the easement does curve a little bit, but
And the purpose of that is the access of the other 2 parcels?
yes, those other 2 parcels were Stacy family, and when the front parcel was created, they divided off the rear 2 pieces and gave easement through, and it was family easement, so. It was done back when the Stacy's
My
still.
2 questions. What, with the family exemption, why don't they just get a rezone?
That
Are
was,
we rezoning here?
no, we are,
And they don't own these front.
but they,
Okay.
Someone else. It's not the Stacy family one.
Somebody else on it now?
Yeah,
yes.
someone
Oh,
else.
Yes,
okay.
Metroline sold it, I'm
Okay.
sorry, yes, Metroline
Okay.
sold the property.
Yeah, it was
Okay, all right, now I get it. All right.
Neil Mitchell.
Neil Mitchell, yeah. Sorry, I wasn't paying attention when it started.
Any further questions? Thank you. Would the applicant please come forward?
Stealing.
My name is Neil Mitchell. I reside at 2745 Filbert Highway, Clover. It's just a couple of miles up the street from this property. I'm north of that. This is actually 2029 Filbert Highway, York. So there's a York-Clover divide kind of halfway between my residence and this. Bought this property. I worked for Stacy's. I grew up working for Stacy's Greenhouses. I worked there my entire life. And Stacy's went out of business. Metrolina Greenhouses bought them out, which is who I currently work for now is Metrolina Greenhouses. I entered into an agreement to purchase this property from Metrolina because Metrolina has a non-compete with Lowe's, Home Depot, Walmart. They can't have a retail establishment. So they've shut the business down. And they put it up for sale for some time. It never did sell. So they come to me and asked, hey, do you have any need? Do you want this property? We talked back and forth. I agreed to buy it. I know the Mitchell Site Development LLC kind of seems to, maybe look at it a little differently with that. I used to do grading, concrete, done some metal buildings all on the side. The Mitchell Site Development LLC, the only reason I have it attached to this property when I bought it is simply for liability purposes. When I bought it, the lawyer helped me, said, let's put it, since you already have an LLC, let's put it in that, so as opposed to your individual name. So that's what we've done. I don't have, I bought it strictly as an investment from Metrolina. I don't want a business out of it. Actually, my son lives in the smaller house, which is to the south of that. He lives in that house, and he uses a lot of that back area just for storage stuff for his business, like some metal containers and stuff. There's no commercial business going on back there. There's no intent to be a commercial business. Again, I work full-time for Metrolina Greenhouses, so it was just an investment opportunity for me at that point. A good friend of mine lives in the house in question, the big two-story house, and he and I were just talking one day. He was asking me how I ended up with it, and I told him one day it's either going to be my son's or we were going to sell it, whatever the case may be. And then he expressed some interest in buying that house. So I didn't plan on selling it, hadn't went to a realtor or anything like that. The guy that lives in it, he's a real good friend of mine from York. His name's Mike Smith, works at York Electric Co-op. And he's been renting it from me for a year and a half, maybe, close to 2 years. And like I said, he just, we got to talking, struck up a conversation about buying it, and he said he'd like to have it. His wife really likes the house. It's a really old house. It's built in 1912. Very solid house, but anyway, so that's kind of where we are now, and that's why I'm asking for the variance. To your point about the easement, of course, when I bought it from Metrolina, we went through the closing with the lawyers. They, of course, reminded me, again, me growing up there, working there my entire life, knowing when Mr. Stacy separated the two houses from the business as a protection, and that's exactly what happened here. There is that easement. That green line does actually own the plat, if you will. It actually shows easement all the way back to those two properties. And of course, when I sell, so the blue line has the easement there. So we're not doing anything with the blue, right? It's existing. So the easement's there. So when I sell the part in red to the buyer, that easement will then be put in that new plat. With Mike's attorney, I think Mac Bryce is handling it, but anyway, he's fully aware of what we're doing. So all of those bases have been covered there. And as mentioned, the house is existing, been there for a long time. There's no construction, nobody's building anything. It's like a half moon driveway, circular drive, if you will, so it already has access 321, has had that for quite some time. Prior to 1987, there was that house was on its own parcel. Mr. Stacy bought that house from individuals who lived in it, and then that's at some point around 1987 or thereafter, he incorporated all of that into one piece at that time. So it actually, at one point in time, had its own parcel, and it was very close to that 1.356 acres. I submitted that paperwork to the county showing the old parcel prior to 87. So we're essentially putting it back almost exactly the way it was before. So again, it's just strictly the fans wanting to buy it. House is existing, it's not building anything. I don't have any plans in the rear. I'm not developing anything. It's just one of those deals where it just kind of worked out with he and I.
All right, Mr. Mitchell, any questions? No? Thank you. All right, we'll open it up for public hearing. Anybody here to speak in favor of the application?
My name is Wallace Tinsley. I'm pastor of Filbert Presbyterian Church, which is almost directly across the road from this piece of property. I live at 1399 Filbert Highway, York, South Carolina, and the church address is 2066 Filbert Highway, York, South Carolina. And I don't know much about easements or anything. I do know about Good Neighbors, and Mike Smith's been there, and I'm very thankful that he can move, hopefully can move from a rental property to owning the property. He's well respected in the neighborhood and in the community, being a member of the school board. I've ministered for 40 years there to, taking that green line all the way back to the Paxton house, Ms. Stacy Paxton Stacy house, and then Ben Smith's mother on the other side, Ben and Berwin, across the road at Peachtree. I think I'm very interested in traffic, and I've been watching the traffic for 40 years at that spot, and the wrecks and everything there. I'm very interested in that, but I can see that Mike's there with family, whether he owns it or not, that's not going to make any difference to the traffic. So I hope you'll approve it. Thank you.
Thank you. Anybody else to speak in favor of the variance request? Anybody here to speak against it? Seeing none, public hearing is closed. Do we have a motion from the board?
Make a motion to approve with conditions listed by staff.
I'll second that. Motion to approve variance with the three conditions listed in the package. One, the division of the lot shall be in substantial conformance with the proposed plat. And then 2, individual utilities, well and septic shall be provided for each of the lots and shall be entirely contained on each of the lots. All wells and septic systems must remain on their individual lots. And 3, the access agreement along the north side of the lot shall be recorded and shall remain in perpetuity for ingress and egress for the existing lots to the rear of the parent parcel. Any discussion?
I just think it as staff recommended, it does meet all 4 criteria. It takes what is currently a non-conforming piece of property and actually with the division of the land creates new lots that conform better. So it makes sense.
Yes. All in favor of the motion, raise your hand. Thank you. All right, next case, Z21-28.
Our applicant for this case, my clicker will work, is, there we go, Patty S. Meyer. Her mother owns the property at 628 Owens Road. It's zoned RUD, and they're requesting a road frontage variance of 100 feet. The property here is zoned RUD. You can kind of see it's a regular nature here. This is also just north of York. And you can see on the vicinity map, a rural area. And then this, okay, all 3 colors are currently 1 lot. And the current lot, the total acreages, and I wish I had gotten all these calculations out, a little over, close to 8 acres for the total lot. And that's my mistake, I should have taken care of that before I got up here. So they have a larger acreage, but they have a very irregular road frontage. They purchased the land in 1967 with this regular road frontage. That little sliver belongs to somebody else. So we are showing that the applicant is the daughter of the current owner. She would like to divide off the back piece and put a home out there for herself to be near her mother. The family, it does not meet family exemption. It does not have enough acreage. And the length of ownership by the current owner is only 11 years. All right. So for A, the subject property currently has conforming road frontage on Owens Road, but the long and narrow irregularly shaped lot was purchased by the family in its current configuration 1967 And it has a large amount of acreage that does allow for additional uses, but it's limited by the relatively small amount of road frontage. So staff finds the proposed variance does meet the criteria of extraordinary and exceptional conditions.
Hey, question there, there's a contradiction. They've owned it since 67, but they didn't qualify because they only had it 11 years.
The current owners only had it 11 years, but they also don't have 10 acres.
Oh, okay, well, the 11 years is what threw me.
Right.
But who owned it in 67?
I believe it was the husband. It might have been.
Oh, that's a real bureaucratic technicality. Okay.
Line and circled it.
Okay. All right, never mind. I'm sorry. Don't listen to me. Go ahead.
The strict reading of the code. So for B, one other lot in the vicinity is similarly shaped. However, that lot does have the road frontage proportionate to its width instead of the narrower width this one has. So staff finds that the conditions do not generally apply to other property in the vicinity, and the variance does meet this criteria. For C, the long narrow shape of the lot prevents the property owner from creating an additional lot with legal road frontage for a new home. A lot of typical shape and depth would be able to utilize the equivalent acreage for subdivision more readily. So staff finds that the variance does meet this criteria. And then D, the surrounding lots are all single family in use and generally meet or exceed the minimum lot size for RUD zoning designation. An additional lot and a single family home will not detract from the surrounding neighborhood or the public good. So staff finds it also meets this criteria of the variance. So staff does recommend approval since it does meet all 4 criteria, and it's an approval of the 100-foot road frontage variance. We do have these somewhat standard recommended conditions of approval. The lot should be in substantial conformance to the proposed plat. Number 2, individual utilities, well and septic shall be provided for on each of the lots and shall be entirely contained on each of the lots. And all wells and septic systems must remain on their individual lots. We also recommend a 30-foot legal easement to the existing curb cut, which was shown in green on the previous slide, shall be recorded and shall remain in perpetuity for ingress and egress to the lot to the rear. That does have one change from the plat that was submitted. The plat that was submitted showed the easement going straight out to the road, but we would recommend a little curve to hit the curb cut there against the road, just to clear up any easement legalities later on when we are no longer with us. Do you have any questions for staff?
Yes. So it says the lot is just under 200 feet in width along Owens Road. So is that the top blue line there? That's 200 feet?
It's almost 200 feet.
And the requirement for road frontage is 100 feet?
Yes. But the other problem they have is there's a house in the way.
But there's no, I guess is a easement across the property better than extending the property to the road with 30 feet or 40 feet of width?
It depends on different situations. There are bonuses and detractions from each side that I've run into. So they've requested an easement, we go with an easement. But to do the 30-foot width would require another road frontage or another encroachment onto Owens Road, which would be very close to the current encroachment of the driveway.
So the green matches the current curb cut.
The
that's
current curb cut is right next to the green. So our condition number 3 would be to have an angle to the easement, like turn a right angle against the front. So
It works out.
All right.
That's to the existing
Curb cut.
Any other questions?
What's the frontage requirement on Owens Road?
100 feet.
How much?
100?
100.
Yes, sir.
Thank you. Ms. Meyer?
at 628 Owens Road. The 11 years we were talking about, my father passed away 11 years ago, so the property was left to my mom. In those 11 years, her health has deteriorated. My brother does live with her, which since then he has developed diabetes. So my hope is to get closer to be able to kind of help out there. I did live in York, not that far away, you know, about 15 minutes, but multiple times, you know, she's had to go to emergency room and I'm not there. So what we're planning to do on the 6.63 part of the acres, about 620 feet off the road, we're wanting to put a home, a manufactured double wide on brick foundation. We are wanting, I mean, very nice home, you know, we've already picked it out, everything's ready to go. We were unaware, we knew that there was close, it is 197 foot road frontage, so we were short 3 feet. So that's why we're here requesting that we do have access to the property, to be able to access the 6.63 acres that is literally sitting untouched for probably 20 years. I was born and raised here. I was born in 68, so they owned that land my whole life. So.
Any questions?
Well, I guess the only question, the only question would be, do you have any problem with the easement being modified to allow for a shared driveway?
No, I do not.
Okay.
Okay. All right, thank you.
Thank you so much.
We'll open it up for a public hearing. Is there anybody here to speak in favor of the request?
I'm Catherine Rogers. I live at 730 Owens Road, just west of there. I share a property line with Ms. Sexton. I just kind of want to need a verification because I found this is a little bit different than what was on the website. So this property, the green line, goes all the way down. It's just an access to get to the 6.3 acres, right?
Yes, ma'am. It's a legal access and easement.
Okay, and it's just for a single family home.
Yes, it would be a easement in perpetuity for that lot, that one lot.
Then I am for that. And I look forward to having a little separation there.
Okay.
So please.
Thank you. Is anyone else here to speak in favor? Anyone here to speak against? All right. Public hearing is closed. Do we have a motion from the board?
Okay. I have a motion to approve with the 3 staff recommendations. I'd like to modify the third one to state that the 30-foot easement would be modified to allow for a common driveway at the road.
Mm-hmm.
Second.
Okay, very good. We have a motion to accept with the two conditions and the third modified for the shared drive. Any discussion?
I would like to make a point. We see a lot of these, and I am in the real estate business, and I see a lot of these that get approved, and nobody ever records a driveway agreement. And I've asked county attorney, and they told me that I cannot make that a stipulation, but I would make a suggestion that if this is approved by this board, that I know it's family, and hopefully it always is, but sometimes it's not. And so I would advise, me personally, I would advise you to have a driveway maintenance agreement put in place. And that's just a suggestion.
All right, any further discussion? All in favor of the motion, raise your right hand. Thank you, unanimous? Thank you. Okay.
That's all me.
Next case is Z21-29.
Good evening. My name is So this project is a variance to the required setback for a ground sign. So specifically, the applicant is requesting to construct a new ground sign directly abutting a property line, where the ordinance stipulates a minimum setback of 10 feet. The project site is located at 3312 Highway 21 in Fort Mill, and it is zoned Urban Development UD. Additionally, the site is also located within the Transportation Corridor Preservation Overlay. The site is an approximately 1 acre parcel and is developed with a multi-tenant shopping center. The site is located between Highway 21 and Highway 51 on a triangle-shaped parcel. The property also abuts Narrowway Theater property, which is the property that's directly above this one, and it's under common ownership. So here we have the proposed site plan with the proposed sign location, and that's shown in red, and I circled it there. So just to provide sort of a little bit of context for y'all, so there are pennies for progress projects on both of the highways that surround the site. So one such pennies project increased the road right of way on Highway 21, which essentially acquiring a strip of property along Highway 21. So according to Patrick Hamilton, and he's with Pennies for Progress, this right of way will not be changing. The connection to the Highway 51 connection to Highway 21 will be moving north, and the road section abutting the project site will end in a cul-de-sac at the former intersection of the two highways. So this section of Highway 51 will no longer be a part of the highway once the Pennies project is complete. And now for just a little bit of background information just on the project site. So the property owners purchased the project site in 2018, and they've been making improvements to the shopping center since then. There is an existing pole sign on the property, and that's the location that's shown down there at the corner in purple, that the applicant wishes to replace with the proposed ground sign. Due to the road right-of-way and road projects, the applicant is somewhat limited in options for placement of the proposed sign. The existing sign, it is within the transportation overlay near the corner of the two highways. Additionally, this area is located approximately 6 feet below the road grade.
Okay.
So here is a picture of the existing pole sign. You can sort of see it behind that, that power pole there, and its location near the corner. So a new ground sign could replace this pole sign in the same location with either no variance required or less of a setback variance than what is being requested from the proposed location. However, the applicant purports that the changing grade, so sloping down from the road, will negatively impact the visibility of a ground sign, which is permitted to be a maximum of 12 feet in height. Further, the applicant is currently working on plans to reconfigure the site with improved on-site parking and circulation. They also plan on installing some additional landscaping and sprucing things up a bit. As such, the applicant would prefer the sign at the proposed location as opposed to the existing location. As such, the applicant has agreed to that if the proposed sign location is approved, that the existing pole sign will be removed. So here is a view from sort of a different angle showing the approximate location of the proposed sign right there in red at the edge of the building. And so now that we've spent an awful lot of time talking about this sign, we can finally take a look at it. So this is what the applicant is proposing. It is 10 feet in height to the highest point and is approximately 70 square feet in area. But please keep in mind that I did the math myself, so the applicant may say otherwise. All right, so moving right along to the variance approval criteria. So y'all know there are 4 specific findings of facts that need to be met in order for a variance to be approved. So the first being extraordinary and exceptional conditions that pertain to the property. So due to the road expansion and the Penny's project, the site has lost swaths of property along both rights of way. So due to this loss of land, the areas in which a ground sign can be located has been significantly reduced. Therefore, staff finds that the proposed variance does meet this criteria.
So they can or cannot put a sign back
I'm sorry?
there? Can they or can they not put a sign back there,
Back
where it is now?
They could.
Okay,
They could.
okay.
But they would prefer this
I
location.
understand.
It could be on a, but it couldn't be on a pole if it exceeded the 12 feet
Well, we don't, pole signs are not even permitted.
anymore. Okay, I
anymore.
didn't think so, that's, okay.
And
But,
ideally, we would prefer to see that sign go away.
right, and
If if the purple site, if there was not a current sign there, and you were proposing a new sign, could a new sign go where the purple location?
Theoretically, yes, a sign could go there, and it would sort of depend on, and I get into this a little bit later, but it depends on, a variance may be required or may not be required depending on the exact height and design of the sign. Because like I said, there's maximum of 12 feet in height, there is sort of this grade issue, and so that's why they were hoping to put it back towards the building, plus the additional site improvements that they're hoping to accomplish on the site.
But the same dimension criteria and everything else applies whether they put it there or beside the building, correct?
I'm not quite sure.
You're making it sound like they can build a different sign by moving it beside the building than what they can build in the front. But they could build the exact same sign in either place, correct? It's just to be lower to the ground, they're worried about people seeing it because of the height of the highway. You tell me it has to
Yes.
be different?
Yeah, I mean, yes, I mean, in terms of height, it is 10 feet in height. I haven't reviewed this application or analyzed it for its.
the sign?
For that sign, yes, right in that exact location. So I can't fully speak to that, just sort of.
So basically, you just want to decide, not so much what the sign is, but where the sign is placed?
That's correct.
This one is 120 inches?
I'm sorry?
Yeah, okay.
That's 10 feet.
Is it because this is, why are they here then? I mean, this is where I get lost sometimes.
They're here because they want to put the sign.
With zero.
Closer to the road
Yeah, they
than
want
is
to put the
allowed.
sign, so, you know, right in that general vicinity where that little red mark is.
Oh, so
which
that
is-
site's not suitable, they couldn't just put it up?
No.
That was my earlier question. I guess you didn't understand me, but.
Go back to the plan.
Yeah,
Yeah, can you go back? Okay. So within 10 feet of the property line, because
okay,
they're more or less on the property line.
Okay.
Where's the right of way?
So they need a variance from the setback, the 10-foot setback.
Okay,
Which
that's-
is-
that's-
I believe the
Yeah.
right of way
Okay.
extends all the way to where the, that solid line is, right up
Dark black
against,
line.
where the red rectangle is.
I got it now.
To be clear, that is the 21 side, right?
That is correct.
And 21 took more of their property when they widened, right?
That is correct.
Right.
And the purple ground elevation is lower than the elevation of the red
Yeah,
location.
it's about, you can sort of see there, it's about 6 feet. You can see how it sort of slopes down, how the, I think that's what, Highway 21 there. So you can see how it sort of slopes down. So they did have some concerns over potential height.
And it does appear that it would be obstructed by trees
Sure,
if you're
I mean-
on, coming from 77 down 21.
And you miss
Yeah,
egress and ingress, too.
I think just overall, they prefer the other location more, just in terms of what they're planning for the site. They would like a ground sign, to be able to advertise all of the businesses in there. They want the best visibility, so they've considered all different sorts of things.
And what was going back to the plan again?
Here?
There's somewhere in here a couple of times mentioned to a cul-de-sac. Obviously, this plan doesn't represent the final.
No, I mean, this is, I just put those red are the two
Yeah.
different colors on there, just for sort of informational purposes.
But
So
what's,
y'all can-
So they're,
where's the cul-de-sac?
they're gonna close 51 there?
They're gonna close
I
51?
think
They're
that's going
rerouting
to
it.
be, and I can't really speak to this because I am not part of the Pennies for Progress stuff remotely.
Right.
And to be totally honest, this was Jeff's project, and I am just filling in for him. So my understanding is that it is sort of where those two sort of medians are, that there will be a cul-de-sac of sorts, but that is not remotely up for deciding or discussion tonight. It's just the sign location.
Okay, but just to clarify,
Yes.
there is an ingress easement off of 51 and also one on 21. The one off of 51 is going to be closed and it's only going to be off of 21?
I'd have to.
I'll ask the applicant.
Okay, I have to
Okay.
double check. I
Okay.
can't.
I know, you're
speak
filling
off
in.
the top
Okay.
of my
Yeah,
head.
I'll
I'm
ask the
sorry.
applicant.
No further questions.
Okay, thank you.
Right.
Okay, so we went over A. Okay, so B is that these conditions, so the road acquisition does not apply to other properties in the vicinity. So this property is located on a triangle parcel between two highways and two road projects. The low number of location options for a ground sign is unusual, even for a property impacted by a road improvement project. So therefore, staff finds that the proposed variance does meet this criteria. And then moving on to C, so because of these conditions, the property owner would not be able to utilize their property fully. So there is an option, and we just sort of talked about this. So there is an option to place the ground sign at the existing pole sign location with either no setback variance required or less than the 10-foot variance, depending on the size and sign design proposed. So while the proposed, while the pole sign location is lower than the road, this location would still be visible from Highway 21. Because the applicant does have other alternatives to the proposal that do not require a variance, staff finds that the proposed variance does not meet this criteria. And then moving on to D, the granting of this variance will not be of substantial detriment to the adjacent property or the public good. Staff finds that the proposed variance does meet this criteria, so having a ground sign is standard for a business property. Zoning staff has contacted Pennies for Progress and SCDOT about the proposed sign location, and they did not express a concern about the location. So then moving on to our recommendation. So because we were not able to make all four of the findings, staff does have to recommend denial of the sign setback variance. However, the board it is within y'all's purview to find differently, and in the event that you do decide to find differently and approve this project, we did provide some conditions of approval. We would like the sign to be set back at least 1 foot from the road right-of-way. And second, that the existing pole sign on the property needs to be removed. And third, the existing concrete in the area around the proposed sign location shall be removed and replaced with landscaping. So that's sort of what this one here shows, attachment 1, and I'm pretty sure it was included in y'all's packet, but just sort of this area here highlighted in blue. We were wanting all of the concrete pulled up and mulch and landscaping and all that sort of stuff put in to soften the sign and to beautify the site.
Anybody got magnifying glass?
Go back to your conditions. I got one that bugs me a little bit. These are businesses, obviously.
I'm sorry?
These are obviously businesses, and they got a sign up. Here's where I'm at. Come buy something.
Mm-hmm.
And you all say the existing pole sign's got to be removed and everything before the approval of the new ground sign. Don't you think they ought to be kind of allowed to have a sign up that here's where I'm at before you take all the other signs away?
I don't think that sign is in,
It looks like nothing's on it, so the only reason I'm asking.
yeah, I don't think it's currently, has anything, in use. I don't think it currently has anything in it right now.
Yeah, it's empty now, but I was
Yeah,
just curious. I mean, the businesses, they don't, what if we decide we wanted a foot 3 inches to the left, so see us at the next meeting 30 days from now, what's your business do waiting on people to find them? I don't like you see what I'm saying?
Yeah, well, but as far as I know, there isn't any signage up there, so the removal of that sign shouldn't have any negative bearing on any of those businesses.
Would you, if you had a business, would you want your sign down for 30 days?
Well, let me ask this question. Can they, within right,
No.
Is it?
do whatever, I don't know.
No, because it's on pole.
Rework that sign.
Can they, what, I'm sorry?
Can they put the signage back?
Where
On
it's
the
empty,
pole.
can they
On
put new
that pole.
signs on the pole?
Can they put a sign on that pole?
Yeah, I mean, there's nothing that is precluding them.
It's
from putting-
grandfathered in,
yeah,
basically.
From putting in, it's called change of copy.
You just
putting
can't build a new
face in.
pole.
Okay, so I agree with you.
Can't build a new
It-
pole
it-
sign there.
That is
I would
correct.
probably change
Yeah.
the wording. to
So you
say
can
at
utilize
time
what
of
is standing there now.
Yeah, let's reverse
Bill,
that.
yeah.
The other one's gotta come down.
All right.
Okay, just in case they wanted to use it.
Hunter, I stand.
They're busy right now. You might wanna go to the green room.
So this concludes my presentation. If y'all have any additional questions, I'm happy to try to answer them. I believe the applicant, Alicia Hutchinson, maybe, should be here to answer any questions that y'all may have for her.
Thank you, Rachel.
Thank you.
Thank you.
All right, would the applicant please come forward?
Good evening. My name is Alicia Hutchins. This is Yvonne Clark. I'm Operations Manager for Narrowway, and Yvonne is our President for Narrowway Productions. And today we are representing property through 312 Highway 21 in Fort Mill. You all have brought up a lot of great points that have been our questions to the county for the last 2 years. Currently, we have no signage, proper signage for any of our tenants, and they have definitely let us know that that has been an issue within their businesses over the last 2 years, as I'm sure you can imagine. We have been trying to get proper signage, and specifically with the pole sign. I had spoken with Jeff several times about this project. When I asked him specifically about the pole sign, if we could repurpose the pole sign, we were told that that was not an option, as pole signs are non-conforming on the Highway 21 based on code. From that point, because that was our first thing that we looked at, so from that we moved on to the monument sign. We said, okay, we need signage for our buildings, for our tenants, so what can we do that is conforming to the 21 codes? So he suggested monument signage. So we explored monument signage, and we developed and designed with a company in Rock Hill this beautiful monument sign. And so then we decided, or we were working on where to put it, and then we looked at all of the setbacks, variances, and everything that we needed to look at to consider replacement. And we found that with a 10-foot setback, really the sign would have to go in the middle of our parking lot, which I'm sure we can all agree is probably not the safest place for a sign to be. Also with our parking lots, we weren't able to take up a parking space designated for signage. So then we I started exploring other options again with Jeff. You can see why this has been a 2-year process. He was actually the one that suggested that we fill out this variance application and begin this process. So it was on his recommendation that I began moving forward with this application. The reason that we are looking at the specific location that we're looking at versus the current pole sign location is a lot of it has to do with the 6-foot drop off. It really is. I don't know if you've been around that area lately, but if you drive at that corner at 21 and 51, you can see it's almost impossible to see any signage that would be put even at the max height that we are required to keep. Right there on Highway 21. It does decrease visibility quite a bit. We are also looking at the pennies for progress changes that are coming in to answer the question. Both 51 and 21 entrances would remain, but SCDOT is looking at we have come on to an agreement. They are relocating one of the entrance to the property there on 21, which is another concern of ours and why we are suggesting and asking for us to be able to put the monument sign on the concrete pad area. Is when that entrance gets changed, we believe there will be some, actually a great deal of confusion because the signage will be after the entrance, the new entrance into the property. So we were really concerned about flow there as you get off the interstate. The proposed location would be sure that anyone entering the property would see the sign before they hit the driveway. So to us, that made the most planning sense. So we were really trying to work with future plans that SCDOT and Pennies for Progress has. So those were some of the main points, but the biggest one is really our tenants need signage. They need to be able to let everyone know, and we have worked diligently to conform to all of York County's requests and codes to make sure that this whole property, this whole upfit has gone according to plan. We've worked tirelessly and endlessly to make sure that this corner is beautiful and a great entrance into York County.
I have a question. Do you own the billboard?
Sir?
Do you own the billboard?
Do we own the billboard?
Yes.
We do not own the billboard, but Adams Outdoor Advertising does have 2 billboards on our property. And we've actually in the past asked about relocating the billboard to where the pole sign location is. So we don't own them, but Adams Outdoor.
But it's on your property?
It is, yes, sir.
Okay. I was gonna make a recommendation, just use that as your sign. But
We have been there and we have asked all those questions. We actually did try to get approval to move, actually in conjunction with the 21 Pennies for Progress project. We have tried to get approval to move the billboard to actually where the pole sign is located now to see if there is any workable situation with that.
So you mentioned, I know this is an old plan, obviously, that as part of the 21 work, you've negotiated a new entrance. Can you give us some idea where that is?
Absolutely. It is actually located very closely to the current pole sign, what's marked in purple on the drawings.
So it's going to slide.
It would be
slide to the south?
Towards the corner.
Yes. If you can pull that.
Yeah, because
up.
the new location, you've already passed the driveway, haven't you?
Yes.
Yeah, that's kind of, I don't like that.
Right. So the way that it would lay out as you're coming off the interstate is you would hit the monument sign. And then right now you can see the driveway is located just near the monument sign proposed location. It actually is sliding closer down to the pole sign side, but still at that point, most of our traffic is coming off of 77. So at that point, they would be hitting the entrance and then the sign, which is where we feel a lot of confusion would come.
Okay, so
you keep
your
it at the
entrance will
current.
be on the other side of, looks like there's a well
So
or
your
something
proposal
there.
is the red?
Yes, our proposal is the red.
But the entrance will slide further down the property past that well?
Right, yes.
Okay.
It would go on the other side of the
And-
well, closer to the current pole sign.
Okay, and are they giving you a left-hand turn into your property?
Yes.
Yeah.
So the
Judging,
So when we looked at the actual photograph slide, there were some trees there. So I'm assuming with the new entrance, those trees will be gone because we were talking about visibility with the current sign where it's located. So those,
Yes, with that, all of that would adjust out.
right, okay.
so I don't have a magnifying glass, but Miss Ray's glasses told me that it's about 11 foot from the edge of the road to the edge of the building. Is that about right?
Yes, 11 feet.
Property line to the building.
No, that's off the
Are you
edge
talking
of
about the concrete pad area? The end of the building?
Into the
from
building.
the building to
Right.
not the property line, to the edge of the road, right away.
And one of the.
It's 11.
One of the
That is the
obstacles
property
we've been
line.
facing in this is the property line runs
This way.
right, there's
So
a grass
yes.
area that you can't necessarily see on the
Yes.
site plan.
That's
There's a
fine.
grass area and then the concrete pad. The property line runs straight through that portion, so the grass is part of SCDOT right-of-way, which I've been in contact with them. And obviously we can't put this sign there, But it runs straight down through our parking stops. So the parking stops almost mark our property line. So really, where the pole sign is currently is the only even sliver that might work with the actual setbacks. But then we're facing all the obstacles with visibility, safety once the new driveway is put in, things like that.
But it looks like you got room to put the 10-foot, almost 10-foot wide sign, 1 foot off of the right of way.
Mm-hmm. And that's what's part of the conditions.
Yeah.
Right, yes,
Yes.
and that was
And
part
that's,
of the conditional.
that's still gonna be, what, 40 feet off of the road, I think.
I believe.
Stay close to it, yes.
Which one, it depends on which one you look at. This one says 10 foot 9 inches, and this one says 11 foot.
Oh, yeah. Well,
This one says 11, this one says 10 foot 9 inches. The
You mean-
sign is
you mean wide?
17 inches, and I'm not that quick at math, but it's pretty close to that.
Any other questions? Thank you.
Thank you.
Is anybody here to speak in favor of the request?
I'm Yvonne Clark, President Narrowway Productions, and I'd just like to say that we appreciate you listening to us. And Alicia has done a wonderful job, really dotting all the i's and crossing all the t's to try and make this happen. For almost 2 years now, we've been trying to get signage on this property, and it has been a nightmare. And to address your question about the billboard, we originally tried to do that. Currently, what we have is an agreement with Adams that for one side of that billboard, it's Narrowway, as opposed to them paying us to have the billboards on the property. There are actually 2 billboards on their property. So the first thing we did was try and put it where that pole sign is, because really, if you look back at that slide, the only thing that really could ever work there would be a billboard to be above that mess of wiring. This sign that we're looking at is a very beautiful sign. It's going to cost us in excess of $15,000, which is a whole lot for us. Slap that in the middle of all those wires is just ridiculous. If you saw the original slide where the pole is. So the billboard was, that's what I'm talking about. Plus it's down where nobody can see. And we feel like it's a safer thing, even people trying to see what's there, to be able to see it quickly rather than trying to look down in that mess.
Mm-hmm.
So our plan is to remove those trees, to have beautiful landscaping there. And I'd also like to address the request to move all the concrete and all that stuff. All those kinds of things are pretty expensive for us right now. We intend to make it a beautiful location for that sign because we're spending a lot of money on it. But I hate to be told that, you know, it has to be, all that concrete's got to be brought up. And I don't really know what we need to do there just yet until we get the sign and everything in place. And then we hope to make it beautiful and remove those trees and have beautiful landscaping around it. If you remember what that area looked like beforehand, we're working really hard to change the whole countenance of that area and keep it like it was intended to begin with, for family friendly for the Fort Mill corridor. So that, hopefully you see our hardship. And then these businesses, for almost 2 years, we've been promising signage, but they have none. And the actual billboard that we use right now is only a location sign, because people, tour buses coming off the interstate, they can see where we are. So it's a location sign for us, but the specific businesses, it would not accommodate. So there are a whole lot of reasons for it. We've done a lot of research, a lot of work on it. So hopefully you all will grant us this. I appreciate your time. And if there are any other questions I can answer, I'll try my best to do that.
Well, I have a question, and it was more for staff, but it's in reference to what you were saying. Condition number 3, they talk about the existing concrete and how it has to be removed and replaced in landscaping. You did not put any time frame. Did you? So as long as they do it in a certain time? I mean, because obviously she said right now with the hardships of waiting 2 years for this and everything else.
Sure. No, we did not put a specific time frame on it, and we would be amenable to working that out with what works for the applicant.
Okay.
Yes.
I just wanted to clarify that. Thank you.
Also, if I can ask, I mean, are you asking all that concrete or just the concrete where the actual sign is there?
The area around it.
Because there's concrete there that we hopefully will use maybe for some outdoor seating. That's going to be an ice cream. Hopefully, if we can get all this done, we're working toward a grand opening in the September time, but we have to have a sign
Mhm.
that go on, so we don't really want to necessarily pull all that up.
Well, right, right now, it looks like traffic can go through there, but with the sign there, that would eliminate that.
It will, eventually, we're looking forward to what they're gonna do, or what they've said they're going to do with those roads. And that's gonna all be closed off, and we're trying to make arrangements based on what you think is gonna happen in the future.
Oh, goodness.
It's a little bit hard, but that's our best guess for that.
Well, I think your last comment was in reference to the blue box in the
Yeah.
picture. Yes. It appears that you can drive through that now to the other side of the building. But if that sign is placed there, that will impede a driver's ability to go through there, correct?
I'm not sure what you mean.
Yeah.
So that's actually not a drivable area. You can't see it in this picture, but if you go a little bit more on the Narrowway production side, that is completely curved. So it's not designed or meant for a traffic pass-through.
Okay.
Yeah, I'm not sure exactly what you're talking about, but I know right now, I don't think, if I'm understanding correctly.
There's a laser pointer laying there.
The white vehicle you see parked is a food truck. They were located in that end unit and had their food truck there. That has since moved. They're no longer there. And then we are hoping to be able to potentially, based on code, we are working with the civil engineer to expand our parking, increase parking spaces. So we are hoping to, if we can add parking spaces there, we're consulting with the civil. So it is our plan to make that a space that you cannot drive through, but you can't currently because it is curved when you get to the other side. It serves more as a patio.
And also back to the pole sign for just a moment, was requested that we remove that before we have signage. Right now, there's nothing on it. We hate the pole sign too, just for the record. I know Jeff wants rid of the pole sign, we want rid of the pole sign, but we had enough sense not to get rid of the pole sign until we knew we had something. So our goal is not to keep the pole sign, so we're all on the same page. However,
All right, staff.
until we have a sign.
So they're under the impression that they can't have the pole sign. You
Well,
said they can have the
so-
pole sign, so what's going on here?
So I've just had a little sidebar conversation with our county attorney, and in light of some new billboard and signage legislation that may very well apply to this project, and the need for a variance, we would like to request to defer. My understanding, and I'm sure Ms. Dover can speak a little bit more clearly about this in terms of the language for the legislation, is that if there is any sort of signage that's impacted by these types of roadway projects, that they can keep it, but they can't take it out and put the exact same thing back. They could potentially raise it or turn it ever so slightly for better view. Anyway, I apologize that this information has just sort of been brought to our attention
After 2
at the
years.
last minute, but it could have a significant bearing on this request.
Well, in light of what she just told us, what's your position? Would you take the risk of us possibly approving it and then maybe having to tear it down?
Well,
Or do you want us to defer it after you've been waiting 2 years? I guess we're looking to you for.
I feel like I'm between heaven and hell.
And this is, my heart just feels so terrible for you, but.
We seriously need some help because we're trying to, I mean, it's been an endeavor for us. We opened up these businesses during the COVID pandemic,
absolutely.
and we're just so thankful to be alive. And these business shop owners, as well as the businesses that we have in there, nobody really knows what's there except just by word of mouth.
Sure.
There is no signage.
Right.
So obviously, we need to not wait another minute. We need to be able to move forward. Likewise, for heaven's sakes, if I thought we were gonna spend $15,000 on that sign, and then somebody was gonna call us and say, oh, by the way, tear it down, you know.
Well, you haven't figured out exactly what kind of sign you're doing yet, so maybe,
We have
Yeah.
the sign.
Yes.
the
So,
plan,
so,
we got it all.
but
question
in
to you
lieu
is,
of,
would you like for us to, vote on what you proposed as a sign and the location, or would you rather?
sort this out with
Then you
what's,
could decide whether you wanted to build it or not. I'm not sure how the legislation impacts that.
Is that, it actually passed
Because
legislation?
I don't, you know,
Yes.
that's still something you guys are
Does
gonna
it
have to
give
work
them a
out,
better
but
place
from
to
what
put the
I'm hearing from y'all, the
Or
current
does
pole
it-
sign is not
I'll
really
wait
doing you
until-
much good
It's
anyway.
not doing anything
Yeah.
for us. The only thing we do is put a banner up there occasionally to
Mhm.
say this is open or that's open.
Which-
We haven't invested anything in that sign for obvious reasons. So, I don't know.
But if we pass this,
they can still do it
they
or
can
not do
still
it.
do something, or at least if
Tweak
there's
it.
something down the road that may impact it,
It's
then
their
that changes
decision.
Can we
at
let
that time.
the
At
county
least
attorney
this is-
expand on what the legislation is right quick? That might be helpful to us.
Sure.
Kind of in understanding what.
So this was Bill 667, this past year in the state legislature. It passed, it was signed by the governor, so it's effective law now. Previously, you had this statutory provision which said if a state highway project was going on and you had to relocate an outdoor advertising sign as a result of a state highway project, then the state would pay to help you move your sign a certain distance out of the right of way. The purpose of this legislation was to also allow that to apply to local highway projects. So if the county is coming in and doing a road project and you have a sign that's within the right of way, the law now says that you can move it within 500 feet to get it out of the right of way. Or if it's just a matter of the project causing some grading that makes it so no one can see your sign anymore, then you can potentially alter the height and the angle of the sign so you have that improved readability that you had before the highway project.
But, okay, based off what you just read, the highway project does not impact her present sign, right?
Or her future sign.
Well, it does.
The grade should
It
change.
does, that's why she's here.
That's why she's here.
From where the original
I don't know.
But
The
it-
grade
Pole
is what it is
sign.
today. And
if I can dumb this down for me, so basically it's saying, if they impact your sign, they'll give you some money and help you relocate it. Is that
Yes.
basically what it's saying?
That's correct.
Okay, if we grant this variance, does that go off the table for her?
I would have to evaluate that. I mean, this variance is specifically allowing her to move the sign to a certain place.
Right, yeah.
I think it might be helpful in this situation for us to be able to further evaluate this and see if it falls within those parameters.
Well, my question would be, it really doesn't, if we grant the variance, she could wait to build the sign and see how it may affect her.
Well, that's the second place I was going, was
So-
even if we grant it, she doesn't have to build what we've,
Right.
the
Right.
variance
Right.
we've given.
So, and if it doesn't have any impact on it, delaying would just be a delay.
The only danger in that is if they move the sign now, its current location,
Well, that-
and put a sign up, and then DOT, pennies, oops, sorry, then what are they, you've already been paid to move your sign, you already moved your
No,
sign.
no, but she's, if I understand this correctly, this is current, this is
Yeah.
current.
Existing signs only.
No, I mean, this legislation's current. So even if we grant this, she's now got two options. One is to put the sign where she's proposed with the variance, or potentially go pursue this money and put it where they want to put it, or where they've
Yeah,
negotiated with them. So she's got two options now.
Yeah, maybe.
Well, pursuing the money to move the existing sign, the pole sign? No.
I don't think that's what
I
they're
would
saying.
assume y'all have already
the
gone through
pole
the process
sign
with
is
the county and the
I
DOT,
don't
and
think
you
that's
know
what
what
they're
the
saying.
roadway
No,
improvement
Well,
project impacts are gonna be to your property.
We do, yeah.
And y'all done all that, and done all the cost to cure and all that stuff.
I've done all the due diligence, yeah.
And that, there's gonna be a cul-de-sac where that, my understanding is where that, the best we can understand at this point, where that sign is. And we have an easement onto that cul-de-sac so people can enter from there, but Otherwise, if they come past us and the signage is there where the pole sign currently is, the only option I see is that they would go down, hit Flint Hill Road, and come back through QT to get to any of our businesses.
Yeah,
Ridiculous.
which is, yeah.
And they haven't acquired property from you to build the cul-de-sac. The cul-de-sac is outside of your current property. They haven't acquired any permanent or construction easements on your property.
Because if they close off 51 from 21, they've in essence created a cul-de-sac without moving onto her property. You just won't be able to come off 51 and turn on 21. It's blocked now. Unless they have plans to move it onto her property, and you're saying they've not contacted you about encroaching onto your property, correct? Okay.
Bless you.
So would you like to continue with this variance?
I'm sure we would, if we have the option. You know, like I said, I don't wanna be stupid about this and lock ourselves into something they can come back after we built that sign. And when I say they, I don't hardly know who I'm talking about, because there's just so many, seem like there's just been so many different fingers to this thing that we can't get our arms around it really well. I believe that the best thing for us is to put the sign where we proposed, the best for Narrowway, the best for all the business owners in there, and the best for the public, the thousands of people that come up and down that road.
Visibility.
Easily see the sign. If it goes down, anything goes down that hole, even if we were granted some type of height variance, that location, it's just so low. It's a hardship. It's a hardship all the way down through in front of our business, of all of Narrowway.
Mr. Bourne, I do have a few additional comments. It might help shed some light on the area where they sign. My name is Peter Kosicki. Haven't met all of you yet. I'm their landscape architect on staff. So we've looked at this case and we've designated the area in purple or blue there as where the sign could go, and then improvements to that area based on a couple of factors. So you can notice that the roadway, the parking lot has a pretty narrow throat there. There's no stacking allowed there. So it's somewhat of a safety concern. If you don't fill in that area and you have cars parking in there, stacking. Additionally, it becomes sort of an aesthetic eyesore if you just put a sign in a bed of concrete there. I mean, we do want to look out for the business as well, and we prefer to see that area sodded and added with landscape. We prefer to see, if the variance is granted, we prefer to see a landscape plan that accompanies the sign. And the staff, we definitely understand where you're coming from in terms of your location. I'm a landscape architect, so I do have experience in designing some of this entry monumentation for businesses and such. So I definitely understand your case and concern for this. So.
And we do, I mean, we want it to be a beautiful sign, and certainly we're not gonna spend that money on the sign and just leave it looking sorry around it. We intend to landscape it. We have some ideas and things that we're gonna put in place of those trees. Hopefully it will be a very beautiful area. That is our goal.
So is staff's third condition to remove all of this concrete?
Yes.
But the landscape only is for the area where
It
it
just
was
says
removed.
around the proposed sign, so I mean,
Oh.
are we talking about?
Okay, never mind.
That's 61 foot across. I imagine this sign's.
May I ask why all the concrete?
Well, as I stated earlier, we would want the concrete removed, first for a safety concern on the narrow throat there to just block off any additional parking, potential traffic conflicts of people backing in and out.
We don't have any parking on that, I don't understand.
Right now, there's a car parked right there in the aerial.
That, in that, aerial shot that was taken, that car, some years ago, that car was not supposed to be parked there. Currently, since we've taken ownership of that property, we do not permit parking on the concrete pad.
Okay, so again, this is a recommendation. This is not something that I would advise to do. So as a professional, I would advise you to fill that area in for safety concerns. Secondly, again, from an aesthetic standpoint, I just think it would benefit your business to fill it in with sod and landscape it, but and that's up to y'all. So.
Well, and just in response to what you're saying, understand your
Yes.
request, and certainly want it to be beautiful. side, we've made a patio and made it very pretty, nobody parks on it.
Mhm.
Our intentions are to do something likewise on this side at the ice cream area, so there's an outside area for people, and that it won't be a parking area.
Okay.
All right, any further questions?
Yeah, so, I haven't been there, I can't see the ground level. You are saying there's a curb across here somewhere?
No, sir, I'm sorry. If you look, on this specific image that's up now where it says 103, you'll see a white car parked there. That's the curved area and it goes up, off of the screen. So that's where the curved area is. So it's very clear when you're on site that that's not a drive-through.
Here?
No, if you keep going around the building, like.
Where the white car is.
Yes,
Gotcha, around
yes,
the
up
building.
on the other side of the building. The way the flow is laid out when you're actually on site is very clear that it's not a drive-through, or really a pass-through for vehicles currently.
So it's
But
like
it
a
is,
sidewalk.
it is the
It
same
does
grade,
serve more of a sidewalk.
it is the same grade as the parking lot all the way around. There's no hill, there's no curb. It's the same, it's concrete, but it's the same grade as the parking lot.
Currently, yes. On the front side. The back side, it's not. The back side, it drops off to the parking lot. It's a curved area.
Thanks.
Any further questions? No? Okay, thank you. All right, open it up for a public hearing. Anybody here to speak in favor of the variance request? Anybody to speak against? Seeing none, public hearing is closed. Do we have a motion from the board?
Make a motion to approve the variance.
I'll second it.
With the
With the-
conditions.
With conditions.
All of them?
We need to relist them,
So,
because I'm lost on the.
Can we
I
go
wanna
back to
be
that?
flexible.
Well-
Can we go back to that slide?
Yeah, go back to the slide so I can.
With the conditions,
Make sure.
yeah.
I don't like number two, that's why I'm coming back. God, 2 years they've been fiddling around with this. I would like to make a motion to approve, modify number two to, because if they don't, if they leave that sign sitting there, I won't give the logic, I apologize for getting a lot of order, but if they leave the pole sitting there and then the state, if the state comes in and says, you can get all this money, but you went ahead and moved the sign. Too bad, so sad. And, excuse me, while we grade your lot away. I don't want that to happen to them. If they need to just leave it sitting there till the state comes in, that gives them an option. That was our sign. That's our approved current, was used. So that's why I don't like number two. I think it should be reversed as far as a condition. In other words, the existing pole sign will be removed after the new ground sign is up. Then that way it makes it more flexible for them as we're wrangling through this new legislation that nobody knows anything about. So, I'll make a motion to approve, agreeing with staff on 1 and 3, and we'd like to have condition number 2 reversed to say the existing pole on the property shall be removed after the new ground sign.
Do you put a time limit on after?
Or,
Doesn't matter.
I'm wondering
So
if,
when you,
maybe change approval installation.
I know, like for building, there's a certificate of occupancy. Is there
Yeah,
a
so-
certificate of something for?
I mean, we could say, prior to building permit final. That's what we
Final,
say in
that's-
our office. That's when you call in for your final inspection, once everything is done.
Yeah.
Does that,
And
is that what
that
you were
ensures
talking
that
about?
it's-
Okay.
It goes away at the last moment.
I'll second that for discussion.
Okay.
Were you done?
Yeah.
Okay.
If everybody understood that.
I just have a problem, I have a problem with number 3.
Yes.
I understand staff's point of view about how that doesn't need to be a place where cars can stack up, but, the applicant's telling us that was a one-time thing, maybe it is, maybe it isn't, but I feel like if you put a 10-foot wide sign across there, they're gonna keep cars from, you don't want them parked in front of that thing blocking your sign.
Blocking
So,
the sign, yeah.
I feel like that there needs to be something done I'm just not sure that removal of all that concrete is what it is.
Yeah, because that's more of a recommendation than a requirement.
Right.
Right.
And I think if they put, as they stated, nice landscaping around the sign, that'll kind of fill in that area.
Right, but I was under the impression that the third recommendation was the removal of all this concrete in blue, correct?
Yeah.
So.
Yeah, I agree with you.
I feel like it's a little excessive to have to
little
remove
financial
61
hardship.
foot
Yeah.
of concrete for a 2 foot wide narrow sign.
I mean, can't they
And if
just
you're
put
gonna
no
spend
parking
the
signs up?
expense of putting up a nice sign, to your point, they're not gonna want it, the view of it.
Yeah, they're not gonna let it go to trash.
Right, so how do we,
Do you want to amend?
or would
Well,
you
you can
amend your
remove-
motion?
Removing.
But how do we amend it to make it?
Remove.
To remove three, but amend
Would you
two.
just remove 3?
I'll amend my motion to, amend the motion to, with the following conditions. Number 1 would be
As is.
followed. Number 2 would be restated to say that the sign will be, the old, pole sign shall be removed after final permitting.
So prior
Prior to
final.
final
final
permitting.
permit.
And then delete, number 3.
Second.
Are there landscaping requirements around the sign in the code? Are there code required landscaping requirements for signage, or is it just a, I'm not a sign guy.
The ordinance is pretty silent on that. We do have some minimum building landscaping requirements, but to answer your question, no.
It's based on past signs, yeah.
They
So
got
do-
more rules about permeation and the amount of concrete.
I deal more with the permeation
Permeation.
things, yes.
The only other, in the, I don't know if this driveway is going in or not, but I've heard the driveway may move. If it does move, actually, the sign to me is now all of a sudden a detriment if it's in the original location because it's potentially in a site triangle. And even if it stays out of the site triangles, it's still close enough to it that a solid sign like that. So I actually kind of like this. Initially, when I reviewed this package, I wasn't really wild about approving this, but now that I've kind of heard the whole thing, I think this is probably a pretty good area for a sign.
And I think with signs, visibility
Yeah.
is a big safety factor because if you don't know where you're going and you're using Waze or something, you're kind of looking at at both, the property and you're, trying to figure out where you are. It's important that you have a good visible sign even before you turn, because sometimes, you could cause an accident. It's just important. And I think at grade, versus 6 feet or 7 feet down below grade, I just think it makes more sense just to have it where they're asking. Because I think safety is a big factor, especially when you've got multiple stores and, with multiple stores on a sign, the print's not that big, and I think the more visible it is, the safer it is, especially in a busy intersection like that coming off the interstate. I think it's just makes more sense.
Another quick question for staff. The ground mounted sign is one option, and I don't know if the code allows. What about wall mounted signs on the building? Are there other options for them to get the visibility they need without putting a sign in a setback? I know there's a reason for those setbacks, and the reason we don't have vertical structures within those. Are there other options?
They could do a wall sign. They would be allowed 1 square foot per linear length of the wall there. So that wall against 21 is not very wide.
Really small on that side of the building, yes, and
You
that's
couldn't-
the view
you couldn't
corridor
see
they
it.
need.
Well, and to your point, that was the other thing I scribbled on here was, the reasoning for setbacks, but somewhere I think I saw in the letter in the packet that DOT actually looked at it and didn't have a problem with that sign in that location. So that would be one of the major players in the setback for me.
Very good. Any other comments? Have a motion to approve with the condition as stated, condition 1 and modified condition 2. Right. All in favor, raise your right hand. unanimous. Is that right, John? You just-
Yes, I got it there. I
you
was
delayed?
thinking, I was
thinking.
torn there for a second.
And another one of them senior moments. I thought.
Thank you.
Five to four.
Yes, did we vote on it? We
I
got
don't
interrupted.
think, I don't know if we ever did because we got talking about.
You
something.
moved,
I
didn't
don't
we?
know if we
I
did.
think.
Did we take a vote?
We did.
I think we did.
Made a recommendation.
It was approval. I mean, it was a
That's
unanimous.
right, but did we ever go back and move 5-5 in front of 5-4? Asian. Did we ever complete the task of moving?
My motion to amend the agenda, did we vote on that? It was
We
unanimous,
can
right?
take one now. We just have to
Okay,
take them.
we got off, and so I just wanted to make sure we got
Imagine that.
it.
What, 5 minutes?
Yes. Can we have 5 minutes?
Make a motion?
I make a motion for a 5-minute break.
Second.
All in favor?
Aye.
Yes. All right, 5-minute break.
How you doing, Gimpy? You healed up completely yet?
You prefer to.
Oh,
That doesn't sound good.
Yeah.
Rachel. That wording is
Yeah, well, but it's a permit for, it's an inspection. It's a permit, yes, yeah.
All right, meeting is resuming. Everybody take your positions. All right, our next case is the case number 5, which we moved to be before 4, so Z2131.
Z2131 is another road frontage variance. Pretty much if you see me, it's a road frontage variance. The applicant is Rebecca Davis. The property is at 608 Russellwood Way. That's over in the Newport area. Is zoned RUD, and the request to go 100-foot road frontage variance. So the location here, you see the zoning map. They are surrounded by several different types of zoning. And then the aerials here. You can see the subdivision under development there, and kind of the bottom left of the picture is Rhine Estates. So Russellwood Drive used to be a private road that curved through that major lot, and is now going to be improved and go straight back toward with a cul-de-sac at the subject property. In addition, the development of this subdivision is going to bring access to public utilities. So the applicant will be able to access public water and sewer, and they have every intention of doing so. All right, this is a weird one. So I look at these all the time, and even I had to look again. Okay, so number 1 here is the original configuration of 4 lots, 4 tracts. In 2011, they came back, and the family decided they wanted to recombine and subdivide. So the original intention was to take tracts 1 and 2 and recombine them with half of tract 3. The red line there is down basically the halfway line.
Mm-hmm.
The 2.044 acres between the red and blue line was meant to stand alone, and tract 4 was not going to be touched. However, if you're used to reading plats, in that yellow circle are land books. It's a clerical error by the surveyor and missed by all county staff, and the result was 2 tracts were created instead of 3. So the 2.044 acres was into tract 4. So I'll go back to the aerial footage here. You can kind of see how it's one big tract instead of one small and one larger. So what they want to do is to create the 2.044 tract again. And picture 3 is, I am not a surveyor, and this is me playing with lines, kind of what they want to go back to. This is what they want to create. And we are working on getting an actual plat to come in. Terry Hucks is actually just down the road there and is working with them. So they were intending with number 2 to create 3 lots out of 4 and got 2 lots instead. So with that clerical error, it was a major discrepancy. Staff cannot correct it. They have to get a variance. It would have been okay back in 2011 for this plat to be created by family exemption. Family exemption has changed. Feel free to stop me if you, because, yeah. Yes, various members of the family. So the applicant, the family member of the applicant bought land, not realizing it was 1 tract instead of 2, because they had deeded it out, but it was never recorded correctly.
So basically, number 3, the third illustration, is what they thought they had back in 2011.
Yes, ma'am.
Or 2011.
Yeah.
Okay, but actually what they have is number 2.
Kind of the aerial picture
Yes,
here.
okay, gotcha. Mm-hmm.
Yep.
Mm-hmm.
Yeah. Basically, mistakes were made. Mm-hmm. Yes, Russellwood Drive used to be a private road that kind of wound through the lot in front of it. So when the subdivision came in, they are going to straighten out Russellwood Road, improve it to county standards, and the cul-de-sac on the end of Russellwood Road would give them access to the lots behind there. So, yes, it's a little odd. Correct. The cul-de-sac shown on the plat here is a remnant of the old private road.
So when this plat was created,
Mhm.
and the mistake was made, and this line was missed to divide these tracts, but when that was made, there was no variance needed because of family exemption.
Correct.
Now the family exemption rules have changed. Now the family exemption rules have changed, and you need a variance.
Yes.
The cul-de-sac still exists?
Your mic also.
Does the cul-de-sac still exist?
That little cul-de-sac exists on paper only.
Okay.
It is not the actual configuration of the
Because
road.
that was their entrance to that skinny lot they
Yes.
originally, okay.
Yeah, it was more of a shared driveway.
So if you look at this photo that was in our packet, which is an area, do you know, okay, so obviously it's kind of penciled in where that cul-de-sac is going to go.
Right.
Right. Okay. That's under development. Do you know how long ago this, was? No?
When the aerial was taken?
Yeah.
I believe this aerial is a year old.
Year? Okay.
Maybe 18 months.
Gotcha.
All right, so go back one slide again. So this whole red area should be 2 lots, not 1.
Correct, yes.
And they're wanting to cut it up as in illustration 3,
Yes, which was the original intent.
original intent. All right, let me ask one more question. All right, looking at the acreages across here, and that's why I asked you, it's still in the same family. 11.11, and then it looks like track 4 back over on this other side is 4.383, and then 2.044 in the middle. Okay, maybe it's just 11 and 4, whatever. That meets the family requirement of 10 acres. Why is it not qualified now?
Road frontage.
Okay. But what I'm getting at is why is it the family exemption, you're saying you said it didn't apply. Why?
She said it doesn't apply because of road frontage.
Right, and
Okay.
also the current owner of the land just bought it. He didn't get inherited, he bought it from property
But is it father and son bought it from the other one for $5?
No, it was
$10.
full price.
Okay.
Brother and sister.
Okay.
I'm lost on that. I mean, I know plenty.
But none of these lots have road frontage. They never
Correct.
did.
Never did.
Okay,
But they're creating a new lot that.
I understand.
Yep.
Coming off the new development.
Oh. Okay. All right.
Any other questions, or is that your presentation?
I can go through the findings.
Go ahead. Yes.
All right, for A, extraordinary and exceptional conditions. Yes, this proposed lot was intended to be created by the plat recorded in 2011. The plat submitted contained an error that caused the lots to be recorded erroneously. The intended lot configuration would have been approved as a legal division of land in 2011. So staff finds the proposed variance does meet the criteria. The conditions do not generally apply to other property in the area because this is a major discrepancy on the 2011 plat, and the change in family exemption means the proposed lot cannot be approved by staff. So staff does find this meets the criteria. For C, application of this chapter, the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. The owners did make good faith effort back in 2011 to subdivide their land, but due to the clerical error on the part of the surveyor and the staff failure to detect the resulting major discrepancy, the property owner must now seek a variance to subdivide their parcels. A minor discrepancy can be corrected at the Register of Deeds, but a major discrepancy has to come through planning and development. So staff finds the variance does meet this criteria. Authorization will not be of substantial detriment to adjacent property or public good. It will not. Subject parcel and surrounding lots are all single family in nature, very various lot sizes. An additional lot in a single-family home will not detract from the surrounding neighborhood or the public good. So staff finds the proposed variance meets this criteria also. Therefore, we do recommend approval for this variance because all 4 criteria are met, the unnecessary hardships. And so we recommend approval of the 100-foot road frontage variance. We do have 3 conditions. They are fairly standard. The division of the lot shall be in substantial conformance to the proposed plat. Individual utilities, well and septic, shall be provided for each of the lots and shall be entirely contained on each of the lots. That was before we understood that they do intend to access public utilities instead of going for well and septic, but just in case. And a 25-foot legal easement for the existing curb cut on Russellwood shall be recorded and shall remain in perpetuity for ingress and egress for the lot on Russellwood Way. So that it doesn't quite touch public right-of-way, so we would recommend an egress easement.
Why,
For-
why
yeah.
25 foot?
That's standard, that's the.
Well, that's what I'm getting at. The last one y'all requested was 30 foot. So what's the?
The last one they requested 30.
Oh, they requested 30 foot. Okay.
Now, where, do you have some plat map showing where this 25-foot legal easement would be going, or could you show us? Because you said existing curb cut, that,
It's the new cul-de-sac for County Road, which would be right there at the point, kind of at number 3. Here, I'll show it up higher too.
Shut up there.
Right here. And in these plats, the road doesn't exist yet, which is why we're kind of working around to make it work for these. So,
yeah, there's no existing curb cut then, right?
there will be.
What's the?
This
For this
will
lot,
be's
no,
not existing.
this lot. This lot will need an easement to the existing curb cut. And we recommend a 25-foot one as a minimum.
The existing curb cut that doesn't exist.
Right, the existing curb cut is down
future
outside the
existing.
property.
Yes.
But there will be one.
It touches.
So, and that goes across other properties.
The new curb cut, the cul-de-sac, touches the edge of their property.
But that's not existing yet.
It's under construction. It's
The
almost-
wording is not
Future-
correct.
The future curb cut.
Yeah, the wording in that condition is not correct. Okay.
Okay,
It's not exactly what we're, I guess, tasked to look at today, but how are any of them gonna access that cul-de-sac?
they currently have, access onto their private cul-de-sac. And when the, subdivision was created and upgraded the road, they moved the edge of the cul-de-sac directly to the edge of the old private road.
Show that aerial.
Yeah, it's on the
Show us the
aerial.
aerial. There's an aerial that you have, right?
Yep.
Oh, right here.
So it's
There.
right there on the tip of it, you can see. So the house with the horse track, you can see their driveway coming down. It's the old road there. So they'll have access to that cul-de-sac. We just want to verify, like later on in the future when none of us are here, that the 2-acre parcel has access.
Yes.
So there are no residential lots going in, I mean, this is showing that the cul-de-sac extends past, or the road extends past where it would need to serve the residences of this, whatever that neighborhood
I
was
can
called.
barely hear you.
So the road extends further than it needs to serve the neighborhood that it's being built as part of.
Correct.
And its whole purpose for it to extend back there is to get to those.
Right, it's considered a
properties.
temporary cul-de-sac for future expansion.
Okay. Any further questions? Okay, thank you. All right, Ms. Davis?
Hi, I'm Rebecca Davis. I currently live at 1835 Matthews Drive in Rock Hill. The property was originally bought by my grandparents back in 1953. It was subdivided between my father and his 3 siblings. Since then, the two sisters have sold their property to my aunt and then to my dad. So that's where the split came in. So my aunt and uncle own the 11 acres there. My father owns the other. And it is our goal to move out there as all of them are aging, to be able to assist them with things, and to put a home out on the property.
Okay. Any questions? No? That'll do. Thank you. Open it up for public hearing. Anybody to speak in favor of the request?
I agreed to give my daughter this about 2.5 acres.
Name and address, please.
Sorry. James Parrish, 608 Russellwood Way, Rock Hill, South Carolina.
Okay.
I agreed to give my daughter this about 2.5 acres of land there. If you see that white dot with the red line running through it, that is a canopy my motorhome is parked in. Her driveway will come off past that canopy just a little bit and come across, which we will give her the right of way to come down to the 2-acre property that she will go into. And that is, we are in favor. My sister owns 11.5 acres adjoining us, and she's in favor of this. And Russellwood Way was our driveway. And when the development was built from Ryan Estates, they took our driveway name and took our dirt road, which was a right-of-way, and we go through the development now to get to our property. So they built us a 40-foot wide concrete access from the cul-de-sac into our property. And that is how we access in. And when it was originally divided, that driveway that you see going back to the barn, the mall-looking building at the back there, that was to be the cul-de-sac for all 4 inheritors to access their property from. So if you have any questions about any of that, I've been there the whole time, so I know where all the bodies are buried. You want to say anything? We're in favor of this.
Thank you. Anybody else speak in favor? Anybody here speak against the request? Seeing none, public hearing is closed. Do we have a motion from the board?
I'll make a motion to approve with the conditions as staff stated. Number 1, division of the lot shall be in substantial conformance with the proposed plat. Individual utilities or public which most likely will be the public utilities, shall be provided for each of the lots and be entirely contained on each of the lots. They must remain on each lot, and then a 25-foot future legal easement shall be recorded and shall remain in perpetuity. Thank you, for egress of the proposed lot to Russellwood Way.
Yeah, let's clarify that existing or future, because
just
we
said
need to
it's
make sure.
It sounds like it's existing.
It's existing.
Yeah,
Maybe not on the aerial photo, but he's
Okay.
driving down the concrete.
well, then I'll change it to existing.
Does that concrete extend to the existing
The curb cut, he's coming off the
curb?
cul-de-sac with the concrete driveway, so the cul-de-sac is in place now.
Okay,
Okay.
so it's existing. I take
existing
back
now.
future.
Those aerials will mess you up all the time.
Second.
I just feel like it meets all criteria as staff had stated, and I think back in 2011, this is what they thought they were getting, and there was an error, and I think this is a way to remedy that and make it all good.
I want that on record, staff, we are bailing y'all out on this one.
It happens.
Like Ms. Rhodes pointed out earlier, in 2011, when this was supposed to be done, this would have been a by right deal, so I do not have a problem with approving.
I agree. Any further comments, discussion? We have a motion to approve with the 3 conditions. All in favor, raise your right hand. Unanimous. Thank you very much.
Should have had us put that in there.
If we see 2 more holes on the property, we know what happened, right?
So
All right, next case, 21-30. Appreciate everybody's patience for hanging out.
It should be, if you put it on, it's not in order.
Good evening, Board. My name is Peter Kosicki. I am the county's new landscape architect on staff, and I will be presenting the variance request, case number Z2130. This variance request is for a grant tree removal on 3 parcels of land currently zoned residential RC1 and RUD. This is specifically for the construction of a roadway. The proposed roadway project area totals 4.05 acres located off of Mount Holly Road. The area is currently undeveloped, vacant, and is heavily wooded with southern pine and a variety of hardwoods. The site also contains a series of ponds that are connected by perennial streams. The site is currently divided among 3 abutting parcels totaling approximately 107 acres, which the applicant intends to recombine into 2 parcels to build the YPA Academy. So this is an aerial view of the site. You can see the 3 parcels there. There's an existing single-family residence right off of Mount Holly. The other 2 sites are currently wooded and vacant. This is a drone footage that staff took. You can see again, just kind of confirming the wooded nature of the site. This is the only cleared area of the site where there's an existing single-family residence. You can see that the area is naturally forested with, again, hardwoods and southern pine, longleaf, and mostly loblolly pine there. There is an area to your far back here. That's harvested pine. You can see how it's tightly spaced. And if you go back the aerial here, that right there.
So that road and the next picture, that is what road? Is that 901? No,
That's 901. That's Mount
that is
Holly.
901, okay.
Yeah, Mr. White's house. No, you say there's longleaf in there? I don't think so.
We just saw short leaf in there, but
You mean loblollies, right?
we saw this area is mostly planted with.
Bobby planted the whole darn place in loblollies. It was a farm when I was growing up. That's why I know.
Yeah, well, there's a good mix of short leaf and loblolly in the area. So I mean, we didn't analyze every tree in the area, but we saw indications of both in there. So yeah, it's a lot of short leaf pine here. A lot of the pine is, as you probably know, is either harvested as longleaf or shortleaf pine, or sorry, loblolly or shortleaf.
Loblolly, yeah.
So that's kind of your typical southern pine. So this is the, even though this is a construction for a roadway into the school, it's important to mention that this is part of an overall master plan called Kettle Song, and the applicant, I'm sure, is more than prepared to present their narrative on this project. So it composes of about 250 acres of mixed-use developments, and of note, the project proposes to protect sensitive environmental wetlands. In the area, you can see a lot of green swaths of trees in here are protecting some of the lowland areas, and some of these blue areas are some of the existing wetlands that exist on site. You can see on this next slide that this is the black line there, the black curved line, that's where the road construction is going. Again, you can see, as indicated in the overall master plan, that the road will be serving the overall developments, including some of the commercial. The school there is in purple.
Okay.
So we'll be serving the schools, while some of this single-family residential in this area to the south there. next slide shows the current preliminary plat that's been submitted. Again, you can see the road construction. So this road here is New Indigo Street. This is Rattlebush Road. And now we're getting kind of into the meat of the presentation for the variance. The applicant is proposing to remove a number of grand trees, and it's important to note that over the course of about 2 months, the applicant has submitted a number of tree surveys indicating the various numbers of grand trees on the site. So you can see on March 31st, the applicant submitted a preliminary plat showing the road construction. There was no survey at this time. Staff indicated through review that the grand trees need to be surveyed per ordinance. On May 24th, the applicant submitted a grand tree survey showing 56 grand trees to be removed. You can see the 56 trees there are in the red along the roads. And again, this survey is specifically for the limits of disturbance for the road, not the school. On June 9th, the applicant then submitted a revised survey showing the removal of 37 trees, which is 19 less than the previous. Then again, on June 18th, the applicant is showing 19 trees, grand trees to be removed. And I will let the applicant get into the details of why the numbers have changed. So on this, and then as you can see from this last June 19th survey, we asked for additional clarification. I guess I do need to get into a little bit of details to for you to understand why we asked for an additional survey on June 23rd. So the applicant stated that the limits of disturbance was reduced on the June 18th submittal, which removed some of the trees. And then the other trees were removed due to the hired arborist and their health assessment of the trees. So this June 23rd submittal shows the assessment of different grand trees on the site. So you'll see the limits of disturbance of that outer dash line. That was the original limits of disturbance. They didn't change it to the red line, which is currently shown. The pink trees are shown as the trees that will be removed that are healthy. The green trees are the trees that the applicant arborist deemed as unhealthy. Then you have the white trees, which are outside of the limits of disturbance that they removed from the grand tree submittal.
So this is, you're saying, so from June 19th, there were 19 trees. To June 23rd, there's went up to 31.
Yes. If you count there was 19 trees that have been counted, pink trees, the magenta trees, there was 19 of those. There have been 6 of the green trees.
Okay.
Those are also in limits of disturbance, so those would have to be removed. So that's 25. Then staff, through our analysis, found those additional 6 trees that would need to be removed because of their close proximity to limits of disturbance, and their root zones would be affected.
Right, that was my next question. So those are the ones that would most likely not make it are the ones in white due to root damage.
Yes. So this next slide I've actually indicated which trees would most likely be affected and die based on limits of disturbance proximity.
And this picture that we have right now, was that an arborist from staff? I mean, is that from county that?
This was supplied to us by the applicant's
applicant. Okay, thank you.
And then we circled, staff circled the white trees, assessed that. So that.
Okay.
Yeah. And that's based on sort of a general rule in agriculture that if you disturb more than 1/3 of a root zone at one time, the tree is in jeopardy of dying at that point. So that's pretty industry standard amongst most extensions.
What kind of measurement do y'all use as far as, from where this tree is to where this red line is? Is there a standard? I mean, is it within 6 foot or 7 foot? Well, I mean, is there something that y'all go by?
Well, I guess general rule of thumb is there's a calculation that you can do, and I can't get into this in detail. There's a calculation that you can do based off the diameter of the tree and the distance of the tree. So the bigger the diameter, the more that you're required to stay away from that root zone,
Right.
so that you don't impact the root zone in its health and its ability to absorb nutrients, and also impact the structural integrity in terms of falling over.
So, and was that done to determine these trees y'all have circled right here? Was that calculation used? Is that how y'all came up with it, or you just looked at it and said it's close? We'll probably take that one too.
Yeah, we looked at it based on scale. So this current drawing does not show a scale, so we asked the applicant for a scale to determine that.
Gotcha.
General rule of thumb is you want to go by anything really within 12 feet. You're really jeopardizing it, especially for a grand tree that's over 24 inches in diameter. I've given some analysis in the past based on trees about that size, and that's about that distance. And it's, don't hold me to it, but that's an approximate number that we go by. It's about 12 feet based on a tree that's about 20 inches or larger in diameter. So, and I can give you those statistics if you do want those. I can give you that.
No, I don't do any math. I was just wondering how y'all came up with that.
So, yes. So, as you know, over the course of the 2 months of submittals, the number of grand trees varied from 56 to 19. So it's important to show how many trees and staff is actually accounted for, because it's kind of confusing. So currently, staff has counted a total of 39 grand trees to be removed. And this is based on the 25 grand trees that are in the limits of disturbance shown here, plus the additional 6 circled in yellow. And then because of these varying numbers, staff decided to go out and do their own assessment with the applicant arborist to verify the locations and also health of these trees. Staff went out and verified the health of those trees, but in the process, we found an additional 8 trees that are most likely close to the limits of disturbance. So we added those to that mix. So there's 39 trees. This next slide shows what we would remove based on administrative approval. So the arborist in this previous slide, those green trees, deemed that 6 of those trees were unfit, they were unhealthy, and should be removed due to poor health condition, which is in our code. If they're assessed as in poor condition, they can be removed administratively. So based on our assessment, we deemed that 6 of the 7 trees could remove based on administrative approval. We actually identified an additional 7th tree. Right here is water oak. That's close to the limits of disturbance, so that would have to be removed. And that's the only tree that we disagreed with. Otherwise, there was consensus that the trees were in poor health. They were either dead, had insect infestation, and were going to probably die anyways. Some of them had pretty significant decay. They're probably going to fall over once you do clearing in there. This other one, just in case you need to know, is, again, so it's a 29-inch water oak. The applicant argued that it was codominant. Water oaks are typically notorious for low branching habit. It was just low branching, pretty typical of water oaks. So this next slide, so I've talked about the grand trees fairly in depth here, but there's another element to this variance that needs to be considered. There's the driveway access off of Mount Holly Road. The applicant has stated earlier in conversations with staff that the driveway access is essentially set here because SDOT essentially determined that's where it needs to go. We asked for additional verification showing that SDOT is saying that the driveway location needs to go in this location. The applicant did not provide that information. We reached out to SDOT to figure out to what extent they are contained to that location, to their driveway. We talked to Folk at SDOT, and I guess he has been in primary conversations of that area. And he basically determined that they're showing this location, Mark Folk recommended this location based on the design alternatives that the applicant submitted. The applicant submitted a number of alternatives for the road and the driveway access to SCO2T. Staff has not reviewed those. So we cannot make an assessment as to if this is the ideal location for this driveway cutout for the school. In addition, SUT said that the curb cut location is not a finalized location. There's going to be some minor adjustment here or there for line of sight distance, so it's not approved. This next slide, it shows the mitigation plan. So the applicant asked about mitigation, which is a very valid question. Our current ordinance does not state mitigation within our ordinance. So the applicant submitted this plan as part of removing the grand trees, a condition, and they are submitting a one-to-one mitigation plan. So what this means is if you have a 40-inch tulip poplar on the property, they would replace every inch of that 40-inch diameter tree. So they would essentially be replacing it, for example, for 22-inch caliber trees. This replanting rate is fairly generous when you compare it to some surrounding municipalities. For example, Rock Hill has about half of that, and their heritage tree requirement is 32 inches. Ours is a little more restrictive. It's 24 inches in caliper diameter. It is worth mentioning, though, that the applicant is mitigating for only 25 of the trees on site, not the 39 that staff has discovered. There is an additional about 1/3 of these plantings. These plantings are not shown on site. Now, it will be part of the overall master plan in part of the school, but not designated on site. As staff, it's our responsibility to review this on a site-to-site basis, since this site has not been approved. So now we get to the variance approval criteria. A states that there are extraordinary or exceptional conditions pertaining to the particular piece of property. Staff has indicated that the site features are pretty typical of the natural surrounding area. It's heavily wooded, it's naturally forested. The neighbors to the left and right pretty much exhibit those conditions. The road placement, however, is justified based on avoidance of environmentally sensitive areas. So we did have the opportunity to look at the grading plan that the applicant submitted to us. They are justifiably avoiding a lot of the low points and areas where grand trees would exist. Typically, you find your nicer hardwoods in areas closer to water bodies, riparian areas. So they are avoiding that and being conscious of that. However, access to the site circulation is not necessarily restricted to the proposed location. As indicated earlier, we're a little bit in the dark about the SUT discussions. Because SUT has recommended a location based on a traffic standpoint.
Right.
This doesn't necessarily speak from an environmental standpoint, and has not been presented to staff to assess. So on that note, staff finds that there are other possible roadway locations and that the proposed variance does not meet this criteria. Condition B says that these conditions do not generally apply to other property in the vicinity. Staff says that the project's site features, again, typical natural conditions as A does. Again, it's heavily wooded, it's forested. Staff finds that it does not meet this criteria. Point C, because of these conditions, the application of this chapter to a particular piece of property would effectively prohibit or unreasonably restrict utilization of this property. The application, staff says the application of the zoning code pertaining to grand trees does not effectively prohibit or unreasonably restrict the utilization of this property. The applicant is not restricted to the proposed roadway locations. Even for a school, the vacant site is very large, and the applicant could relocate the proposed locations, proposed roads to other areas that would potentially impact fewer grand trees. Because of this, staff finds the proposed variance does not meet this criteria. And then the last point, D, the authorization of this variance will not be of substantial detriment to adjacent property or public good, and that the character of the district will not be harmed by granting this variance. Staff finds that the removal or death of 31 grand trees, compounded with the removal of hundreds of other existing trees during the site clearing, would substantially alter the rural character of the area of the site. As stated in our intent and statement of introduction of statement of purpose, in this section of the York County Tree Conservation Ordinance, tree protection and preservation standards are established to emphasize the importance of trees in prevention of soil erosion, lessening air pollution, noise, heat, and glare reduction, and the beautification and enhancement of property in York County. So on this note, staff finds the proposed variance does not meet this criteria. Second to last slide, our staff recommendations. Based on the information that staff still feels like we need to assess based on the number of grand trees fluctuating and the lack of information pertaining to SUDT, staff recommends that we defer to allow for an updated survey. If staff would then request deny or recommend denial, if it's not deferred based on that, if the board finds.
Go back. Is that different than? So are you recommending a deferral over denial?
We're currently recommending deferral.
Okay.
But if it is not deferred by y'all, then we would recommend denial at this current meeting, based on essentially a lack of information.
Okay.
Whose updated tree survey are we waiting on? There's one here from Kettle Song, and even has, because what I was looking for was, what are the trees? I'm very familiar with this property. So anyway, but that being said, who's doing a tree survey? Are we waiting on staff to do a tree survey?
We would prefer that a third party surveying or arborist conduct another survey, just because the number of grand trees is varying. An additional note, the arborist, we did recommend an arborist in an earlier application be hired, since they hired a surveying company previously, and there was a fluctuating number of grand trees from survey to survey. The arborist that they hired happened to be essentially on staff for the applicant. So
this survey that was in our package,
yes,
from them, this is what you're referring that to?
yes.
Okay.
So we would contend that it's not a truly third-party survey based on that.
So you would want somebody that's totally neutral come in and
Yes, we would not recommend that we do the survey.
reevaluate the
Or that
trees.
they do the survey on staff, because that would be a conflict of interest.
Correct. Okay.
Have y'all had a forester or anybody review these conditions? I know this property. It's my family owned a lot of this land. And when I was in my 20s, I dove hunted these fields that didn't have any trees on. There are no longleaf pine on that property. It's all planted loblolly in fields. And you got pine, this list is loaded with pine trees, sweet gums, and poplars. That I'm 60-something years old now, so these were planted 40 years ago. A loblolly doesn't live much longer anyway.
Okay.
These were planted as a crop on the list they are giving me. So my question is are y'all sending a qualified forester out there to determine, is this really a grand tree or a planted loblolly?
We make the determination of grand trees based on size.
I was on the tree ordinance committee when it was done in York County, based on diameter. But I'm asking you, where's your list of the trees? I mean, there's an oak here and an oak there. Most of it's pine, sweet gum, but most of it's pine. They're gonna die. There's some of these 27, 28-inch trees, they need to be cut for pole pines now.
Okay.
I mean, the beetles are gonna eat them. So I guess what I'm getting at is, if y'all are gonna defer or wanna deny this, somebody needs to do something like this and come back and not, and not come back with a crop and say it's a grand tree.
So the staff qualifies grand tree based on size.
I know.
So we're essentially going by ordinance.
Okay.
So that's up to y'all to decide if you want to grant the removal of the trees.
So, and just to clarify, it's not a set size. I thought it was a set size, 24 inches.
It's 24 inches.
Okay, so why the second tree on this is a 29-inch oak that says grand tree no. So how's that?
You'll have to speak more to the applicant about that, but what I can
Okay,
see
so they're saying no.
This is theirs.
That's their
Gotcha.
Right.
Okay, that makes more sense.
Was there ever, this is a master plan.
Yes.
So this is, I know we're just looking at the road and the trees that are
In that
impacted
road.
by the road, but there's a master plan. There may or may not be what I'm gonna ask for, but was there a survey done for the entire property that puts this in context? I mean, are we losing 39 grand trees or 26 grand trees out of 200 or out of 75?
The survey was just conducted just for the roadway, so just for the limits of disturbance.
Okay.
So there's a lot of trees that need to be surveyed in the future if the development commences for this as planned. So
Do we have a list of the trees, size, and species that we would be losing with the roadway? I see this list of 73 trees. Do we have a list of actually what we would be losing?
We don't have, he's saying we've got to get something from independent.
We're losing, based on your assessment, 29 trees or whatever the number.
yeah, 39.
39 trees. Do we have a list of those trees and what they are? I assume they're not all loblollies. I assume there's some nice oaks in there too.
Yeah,
But
there's
it
a
would be,
mix.
I would be interested in seeing
Yeah.
what those trees were and what that mix is.
We don't have a list of all the trees. I'm sure the applicant would be happy to supply that.
But you
we
want it,
have-
but hang on now, hold on, back up. But you're saying you don't trust theirs basically, and you want an independent or your own. So,
Yes.
so
based
why are
on-
you saying the applicant's got to supply it? You or somebody's got to supply it, because they did supply a list, 2 pages of them, and most of it's pines.
But he's looking for a third-party
Yeah, so.
survey, and this is not, they don't consider this to be a third-party survey.
Correct.
I'm not necessarily looking for a third party. I want to see a list of the trees that are going to be, the grand trees that are going to be destroyed by this road.
Yeah.
And we don't have it in our packet. Now, we may get it from them.
Yeah.
I'd be interested to see, is it 20 oaks and 19 loblollies, or what is it?
And the little disease list, there was only, what, 1 oak on there, wasn't it? On the 8 that they listed that was in our package. Yeah, the one that's in the little table. I looked at that at home, and that's what's bugging me.
Yeah, there's, so these are the 6 trees we
Yeah.
allow for removal.
But I mean, you
That's-
could get
that's
pine beetles
administrative
next month and knock out 20, 30 acres of those pine trees.
I'm looking
In a
for,
heartbeat.
looking for what grand trees that are healthy that we're losing. That's the list I'm looking for.
Yeah.
So that list would be these pink trees right here.
Right, but we don't
And
know
what are
the
they?
species.
What
Yeah,
are
we
they?
don't know what this, yeah.
What are they?
We would have to get further clarification on that. So they're listed on there, you can't see it based on graphic. There's
Yeah,
a mix
we
of-
know where you at.
Well, you can read good.
So I do need to mention that staff had a hard time assessing the surveys because from survey to survey, go back to this slide here.
Yeah.
From survey to survey, the number of, so not only the number of species change, I mean, the number of the quantity changes, but the locations changed, and then sometimes in the same location, the species changed on that same location.
So
So
basically,
staff can't determine what's actually there.
Well, you gotta get, somebody else gotta do a survey if you don't trust theirs. And based on this, I don't blame you for not trusting theirs. You see what I'm saying? I see the ambiguity there, but I know that farm. And it was planted pines, and there was trims of oaks, and because I hunted on it back then. And they had trims of oaks, and naturally near the water, you leave your oaks and stuff like that. And then, but all the fields, Bobby had cotton out there. when I was in my early 20s, and then they planted it in pines. The sweet gums and the poplars came in from the birds.
What's the county ordinance say
Back when dinosaurs were.
about
Yeah, dinosaurs
about-
were on
about
it.
harvesting, about clear cutting? I mean, you can go up to a certain, distance from a creek or distance from water, but I mean, if not necessarily this owner, but the owner before him, what if they would have came in here and clear cut this whole place?
They could have.
If it was ag, they can clear cut.
They can't clear cut in RUD?
No.
Or RC1, whatever,
No.
whichever one we're talking about here.
It's RUD
RUD
and
and-
RC1.
And then they could have cut every big oak too. So what you're
If
encouraging,
it
if
was ag,
you're not careful, is
are
that.
you saying it's gotta be zoned AGC for them to come in and cut trees?
Yep.
Correct.
That's right.
I think that's what was in
You
the,
mean the clear cut?
The clear cut, yeah.
The intention of clear
Even,
cutting,
even the thin, I mean, what if we'd have taken 400 grand trees out when we thinned it? That's what the point I'm trying to make here, is what are the limitations of coming in and harvesting trees for a cash crop in this zoning district?
I remember reading it was AGR, was the only one that you could come in and.
It can't be the only, I mean, you gotta be able to cut trees.
I thought you
already.
could cut trees, and if you waited 5 years, then you could develop it. But if you cut trees, you
So
have
that's
to
what
wait
I'm
5
saying.
years to
There's
develop.
got to
There's
be
some more rules.
somewhere, a rule
Something in
somewhere
there
that
about
says
that
something
as well.
about it.
I don't
That's
know
all.
all the.
But once you cut the grand tree, you can't develop it for 5 years. And I think you're dead right on that.
I think there's a 5-year waiting period, I
Yeah,
believe.
I think you're dead.
Yes, I can add some clarification.
It says
So-
all grand trees except in AGC and AGC1 zoning districts must be retained on the property. And if trees are removed, any non-agricultural development will be prohibited for a period of not less than 5 years.
There you go. You're
But
on
there
the
you
money.
go.
So the
But-
state,
but
the state does allow property owners to timber a property as if it's part of an agricultural process to sell that timber. And the way the state code is written is if it is an active agricultural site, the final cut, so they intend to develop the land after this last cut, there is a 1-year waiting period for that. But if it is not an active agricultural use and the property owner willfully removes a bunch of trees through a timbering process without proper approval, then that's when that 5-year penalty kicks in.
Well, it's actually agriculture / timber operation.
So-
Because
so-
a lot of farmers went into the CRP programs and planted pines 40 years ago to clear cut those fields today.
When was this tree ordinance enacted? It was recent, wasn't it?
No.
Well, it was amended.
The grand,
in
put
the
the grand.
90s.
February.
It was amended in February? Before it was
But it's
24.
been around
what was
since.
It was 32.
Yeah,
32.
It's been around a long time.
It was originally put in, y'all, in the 90s, because I was on the first committee for the
So-
York County Tree Owners, but it's been modified.
Right, right, but the
So
language
I mean, was it 32 when y'all made it then, or has it
We
changed
fought,
multiple
I
times?
think we fought it down to 24 because they had a farm / timber contingent as well as the tree hugging contingent on that board. And we did that in the 5 years, that's where the 5 years started from. I think the state adopted a lot of that in their BMPs for timber production. But, yeah, there was a lot of people involved in it back then when that went down. But that was a real hard argument, and I've smelled it coming on this one too, is that I know that farm. And there will be agricultural information that shows that farm clear as a bell, except nothing but oaks, big oaks around, and in certain areas and around the ponds and everything else, and the rest of it was wide open cotton fields. And they had cotton on it, and then they quit, got $10 an acre to $40 an acre for 20 years to plant it in pines. Bow Waters pushed that so they could have plenty of supply, and it worked. And they planted all the pine trees in the cotton fields. So when they come back and say it's a grand tree, it gives you the impression that it's some, live oak that's been there for 1,200 years. No, not, these were planted pines.
Based on that assessment, they ought to be able to dodge all the oaks. So I still want to see what trees we're taking out.
Exactly. That's exactly my point, is that on the list they provided, they got pine, sweet gum. The county, if you don't trust their assessment and you want another one, get it and then give us, I want to see a list of exactly what he's talking about.
and it's not that, we don't mean to be contentious, it's not necessarily about not trusting it, it's just that we can accurately assess it because every survey has changed. And it's changed so much that we can't reference the prior one to see how it's changed.
Your proof's right there, sure.
We understand.
Sure, we understand that.
I have a question. I know we're only looking at the roadway here, but what about the entire development?
Yeah.
Or is this whole property been surveyed for grand
No,
trees?
said
Because
Because it said somewhere in here that they haven't gotten anything else. This is all they had right now.
That's what started the whole rant.
So if anything else would just be speculating.
We should have timbered it 5 years ago.
Okay. Any other questions?
Any further questions?
Any other questions?
Not right now, maybe later, but.
Well, there was, I do have one.
Yeah.
There was, I do have one. I do have one.
Oh, you do.
So somewhere in here, let me go back because it's on a whole different line of thought. There was,
I think he has a question. He's,
there was a note in here. I gotta find it. I circled it. Something about when doing research, you found something with another driveway or driveway easement or something?
There is, and this is
I saw
in
that.
in a future phase, this is why I didn't cover it. You can see on this overall plan, if you go to the full screen there, you can see it a little better. So you can see there's a future driveway access shown here. Now, we're not reviewing this officially at this time because it's not a part of this prelim plat. But if you go back to the overall master plan, this driveway here is shown in a faint gray line. That is this driveway right here.
wait.
To access to access those townhomes, which appears to be.
So that's not some kind of access that was recorded 20 years ago or something. This is something that could be in a future, part of a future development.
Yes.
Is another driveway.
Yeah.
Okay.
Where did you see that?
God, I was on here somewhere and yeah. I thought I circled it.
All right, any more questions for staff? No?
Not right now.
All right. We may have some later. Thank you. Could the applicant please come forward?
Good evening. My name is Craig Crace, and I am the owner of the land for which we're requesting the variance. Please note that this is very much so my backyard. I live less than 3 miles from the property. My business partner, Nick Radovanovich, who is here with us this evening, and I are working to develop this land into a pedestrian-oriented, nature-based mixed-use community called Kettlesong. Nick and I have brought our team here this evening to address the very specific concerns that have been raised by the staff. You're going to hear from our civil and traffic engineers who will cover the planning and design process that we went through, which is very rigorous, that's necessary to build roads to serve a public school. There is a lot of detail that goes into that, and we will cover those requirements. You will also hear from our arborist, who will go through in detail with you the process, how we went from the number of trees that you saw and how we've been working and refining to get that number down and to a very accurate count. And to be clear, we have an accurate count that includes sizes and the species of trees that will be impacted by this road that this variance that we're requesting. Not only that, but he's also going to show you our mitigation plan, which I think you'll find to be very robust and above and beyond what has been requested. Finally, as you're considering this request for variance tonight, I hope you will consider the character of the trees. Members of the board, we're not talking about 100-year-old stately oaks. We're talking about 15 pine trees that are part of an agricultural program. To be clear, all of this land that we're talking about is enrolled in the York County Ag Tax Program. I had the South Carolina Forestry Commission, one of their people, out on site earlier this spring to look at how do we continue to manage this pine forest that we have. Out of the other 5 remaining trees, 2 are sweet gum trees, 2 are poplars, and 1 is an oak tree. That's what we're requesting the variance here tonight to replace. And out of those 20 trees, only 3 are larger than 32 inches. 1 is a pine and 2 are poplars. And to be clear, the ordinance in February was changed by the York County Council to reduce what defines a grand tree from 32 inches to 24 inches. Lastly, despite the need to take those trees out, I think if you will consider the mitigation program that we're proposing, which is an inch for inch, which is going to result in more than 200 trees being planted on this property that are a diverse group of native hardwoods, that is a good investment. We should take that trade all day long. And so without further ado, I'll turn the time over to first the civil and traffic engineers.
Okay, good evening. I'm Randy Goddard, Senior Principal of Design Resource Group, 2459 Wilkinson Boulevard in Charlotte, 28208. So I was asked, and what we did is we put together a traffic study for this project for Kettle Song Phase 1A, which was the school site. And as part of that, we started this in August of 2020 to actually start scoping the traffic study. And typically when you scope a traffic study, access is important. You want to know, is it going to work at that location? The process we go through. So we went through all of that with SCDOT and York County staff. It's just not SCDOT, but York County is part of the process for review and approval of the traffic study. So we did that. The traffic study was approved by SCDOT and school operations in April of this year. And 2 weeks later, York County approved it. And again, it was based on the location of that access point that you've seen on this site plan. So what's critical to that is SCDOT school operations really wanted to make sure that the location worked from a standpoint of, does it meet site distance requirements because the road is based at 55 miles an hour? Are we able to make the site work for school, for stacking and operation? And the other thing is that we want the site to work because we recommended roadway improvements at that location. So that location is going to get a 200-foot southbound right turn lane and a 150-foot northbound left turn lane that, again, SCDOT and York County signed off on, and a signal. So we want safe and efficient operation of the school. That's where that location is set for that. Now, the correspondence that's in the packet talks a little bit about there might be some minor variation. It typically doesn't vary a whole lot from an access point once you've gone all the way through the traffic study. It pretty much sets it because, again, access is important to just not, the traffic study, but to ensure that the school is going to operate well. So again, that's what's important is safe and efficient access for cars turning in and out with the number of students and parents dropping the students off and staff. That is critical. So again, SCDOT looked at that and so did York County. So I'd be more than happy to answer any questions related to the traffic study.
Good on that.
So the school is very internal to the site.
Yes, it
right?
is.
It's the purple buildings.
Correct.
So the stacking per se and the movements around the school site really don't have an impact of where the primary location is off of Mount Holly. All that happens internal.
It happens internally, but you need to ensure that the operation works to have all that stacking, which actually is more than 2,000 feet on
Sure,
site.
that's all happening internal, right? Not out on Mount Holly.
you don't want it to happen on Mount Holly, but it's all part of the project.
In theory, you could move that entrance somewhere else and still maintain your stacking internal to the site.
So other locations, I don't know how many others were evaluated, but meeting with and talking with SCDOT, school operations, that this location, Mark Falk, that this location was basically set for that. And that's when we started the traffic study. So all the time from August of 20 through starting the traffic study, we were looking at locations. This one was talked about to ensure, again, we need a location where you can have the access that'll work for signalization. It can't be too close to other signals. You want to have room for the turn lanes to all be able to lay out. You want to have the sight distance requirements. All those are factors. And you also want to be able to have the traffic internally work to be able to get in and out.
Of the school, right. The Mount Gallen entrance is tied to the overall development, not necessarily to the stacking at the school. And there were more, based on just on what that gentleman was talking about, there were some options presented initially to the DOT that the county hasn't seen. Can you speak to that at all?
The county has seen everything because county reviewed the traffic study and the initial scoping packet. So they worked together and they signed off on the traffic study that has this access location.
Right, this particular access, but not other options that may have been explored with the DOT. You don't know, that's right, I understand.
Other questions?
In the master plan that's shown here, there's another road that goes kind of toward the southwest, makes a curve across the stream and loops back around the school. I don't think I saw that on the other drawing. Maybe it did, but is that what's the plan on the traffic on that road? I mean, I see this would be an alternate route.
Are you talking about this?
Yes.
That's for the stacking. That's for the circulation for the school.
Okay. But that's not included in what you're asking for then? Right.
No, not tonight, yeah.
He's not answering tonight.
So we have no idea what kind of grand trees would need to be removed in order to put what we're showing now for the stacking for the school.
So what you've got there, I believe, is for public streets. The circulation pattern's like an internal driveway. The one that meanders around and crosses.
I'm assuming that's where we're gonna get your stacking, the 2,000 feet that you're looking for.
Correct.
And how many grand trees will need to be removed to put in that stacking? We don't know that yet.
Hasn't been
I do
done.
not have that.
That's right.
Right, so we're,
That happens, doesn't it?
Yeah.
so this is only the first piece of the puzzle.
Go ahead. As far as,
Kelly, again, Lightner. So just to speak to the other access points, other access points were presented to Mark Falk with DOT and they were not recommended due to proximity to 5 Point Interchange and the new Indigo Street access that we are proposing. Okay. So those were reviewed with him.
how are you gonna keep, so just another question. So we have an access towards the middle of the property as well. Somebody utilizing the school
This one,
could go through that middle one as well. How do
that's the
you,
one Mark Falk would not allow. He said we would not recommend that.
would not recommend that one? How,
Proximity.
right, how is that gonna be handled? How are you gonna keep parents from using that access for drop off at the school? Or is Mark just specifically took a school bus?
It is not part of the proposed plans at this point, and it is not part of the TIA that was submitted and approved. So it is not being proposed.
Right, but when it gets built,
It's,
it may never get built, I don't know.
It may never get built.
Right.
If the TIA for that future development doesn't get approved, it would never get built. So again, we're just here trying to get the roads approved for the school, which Mark Falk dictated that location to be in the northern area of Mount Holly due to sight distance, this being a downhill slope in this area. He moved the entrance further north to get to the top of the hill due to sight distance issues. And he did not want that access at that location due to the proximity of the 5 Point Interchange.
So, okay, I'm good with that, I understand that.
So that's why we don't show it in the proposed plat.
But I would assume that the stacking, everything that the other consultant is working on, has Mark Falk looked at that, and has he approved that layout for the stacking?
As part of the packet presented to you, he has preliminarily approved that stacking distance, yes.
That distance and that layout. So I go back to, but we don't have any idea how many grand trees that takes.
We have an idea.
Y'all have an idea, but that's not part of our package tonight.
It'll be in your package next August 12th meeting.
Right. Then we would have a grand total of what it will take, grand trees
For
to
the school.
Develop the school.
Correct, to develop the school.
Yeah. Do we know how many grand trees are present in the school footprint? Is it fewer? Is that sitting in the alleys?
It's fewer than the roads, much fewer, I think.
There's a field there, I can tell you that. It's probably most of it.
But it's a combination of loblollies and other species.
It's fewer than which one?
That's right. We only have a very small part of the picture.
Well, we can address that as well, talking about, we're talking access points first.
Thank you. They're parallel. Don't go there. We've got 10 o'clock coming up.
Make a motion to continue the meeting past 10 o'clock.
We have a motion to continue after 10 in a second. All in favor, raise your right hand.
Would the board?
Can we take another break?
Would the board like a break at 10 o'clock?
That's a different question. No, not right now. Yes, proceed, please. Thank you.
Good evening. My name is Frank McMahon. I'm managing partner of Land Design, 223 North Grand Street, Charlotte, North Carolina, 28202. I'm just here. I'm the civil engineer on the project. I'm just here not to talk about the trees specifically, but just the north-south road alignment. And you'll see, so I'm here to talk about this road, which is coming off the proposed roundabout down pretty much through this, what everybody's calling the Grand Tree area. We're looking to remove trees. One of the reasons the road is where it is to be a little bit more environmentally conscious. Like we said previously, there's a lot of pines in that area. And our certified arborist will speak to the types of trees and the sizes of the trees that we are impacting with this north-south connection. One of the things we did do between the preliminary plat submission and what's next submission is we've actually tried to save some additional trees here where there's a natural drainage pattern. So we were trying not to pipe that and fill that area. We're trying to keep that in its current state and honor the natural drainage area and drainage patterns and basically bring the drainage around and not impact as many grand trees. So we're trying to be environmentally conscious also by knowing what trees are out there and how can we save some extra trees. The natural drainage pattern is coming through this area. You'll see that there is a small wetland that we're going to be impacting here, and it's minimal. It's less than 1/10 of an acre. If this road were to have shifted this way, we'd be impacting more trees, more oaks, poplars. Where we are right now is more like the pines that we're actually impacting. Like I said, it's also the natural low spot, so that's where we have our BMP facility. We've even made adjustments to the BMP facility to not impact as many trees also. So we're listening that what can you do to save existing trees, right? So we're trying to make adjustments to the plan in order to, work with staff and the existing trees that are out there. Does anybody have any questions regarding the road itself?
Your water and sewer in that road?
Yeah. There'll be 8-inch water main, 8-inch gravity main.
And there's a
That's all going to be reviewed.
force main somewhere up there?
again?
I remember last time there was a force main somewhere.
Yeah, the force main will be coming, oh, went too far. You don't see those pictures yet, right? So, yeah, there's gonna be a force main, there's gonna be a lift station that's gonna be down here, that's gonna force it back up and out to Mount Holly. In this road itself, this is all gravity fed. That will come across here and then tie in all gravity to the lift station, and the force main will come up. And that's all gonna be reviewed and approved, and hopefully approved by City of Rock Hill Utilities.
I have a question for you. So when you come off of 901, you go to the roundabout, what prevents you from continuing rather than making the left turn, continuing and coming around on the other side of the school? Is there wetlands there? Is there something prohibiting you? It seems like there's less trees there. I'm just.
This area?
Let me look. Yeah, wait, yeah, so go up to the roundabout, just keep going down and then come around on the other side of the school.
Right, and then you come
Yeah.
across this way. There's existing streams, wetlands, so it'd be more impactful. Right now, what we're doing here is we have minimal impact to the wetlands. There's, like I said, there's less than 1/10 of an acre impact to the existing wetlands.
Well, you've got that road going around it and still crossing.
This
right?
one, this is a small, right here, this is a small bottomless culvert. If we were gonna do this road, it would be a much larger bottomless culvert. It would just be, it's really not efficient to bring that road around and try to have that big of a bottomless culvert coming through here. Again, what happens is that wetland streams gets wider, the road's wider, it's not as efficient.
Is this a bottomless culvert?
Yes.
Okay.
So what we're doing is.
So a bridge, pretty much.
Yeah, it's pretty much a glorified non-bridge, right? But with that, right now, like I said, there's a very small impact to that wetland. So coming through this way, I mean, that would be a pretty large bottomless culvert because you're sizing it for very large storm events for life safety reasons.
And I know you said shifting the road.
But like I said, we were trying to be conscious of not impacting this area where the wetlands start to get larger, they start to widen out. There's more trees, there's more oaks and poplars and less pines. I think Craig.
What about the other way?
Before.
Towards the main road, if you accentuated the curve.
Yeah, if we were to go, if we went this way,
Yeah.
there's still trees in that area. Right now, at one point, we were impacting those trees because there's a natural drainage pattern that comes off Mount Holly and discharges to basically to a swale that we were gonna be filling in at this time, but we've decided that we're gonna just maintain the natural drainage pattern and not impact those trees. If we were to get closer, it's kind of an awkward condition when you take a road and run basically up against an existing road. That close, it's a very awkward condition having traffic, like 4 lanes of traffic, like two different roads. So we wouldn't, in my professional judgment, I wouldn't get much closer to that.
Plus you'd lose 2 buildings, and I'm sure they don't want to lose.
With that area where you're crossing down below with the stacking area, what size bottomless culvert do you have to put in there? Have you estimated that?
I don't know offhand. The roads, it's about a 20-foot wide road. So.
Well, that'll speak the length, but I'm talking about size. Is it a significant size structure? Is it so right now that road coming across there will be a 22 foot of pavement?
Yeah, 22 feet of pavement, give or take.
So you can do it with a 50-foot length bottomless culvert with your shoulders and everything. Up there, what is that road? That's is it 4 lane divided, or what is proposed up there?
That's 2 lane, but it's 60-foot right of way. Right. So, but again, it's.
So we're talking an extra 10 foot of culvert length across to do one crossing down lower, which potentially has less trees. Has that been studied?
That has not been studied.
Okay.
I have not studied that personally. As far as bringing that road around this way. This was the most optimal in order to get the frontage for the school and for the staff.
Right, I understand.
Yeah. It's because this is being utilized all of this, and it meanders back.
Yeah, I hadn't drawn it, I'd have to,
It's a pretty
on circles.
long 2,000 feet. Usually when you see these stacking roads, they're winding and
Right,
meandering in order just to get 2,000 feet.
Any further questions on the road?
I do. I know we've kind of touched on this and we've kind of danced around and everything else. But, you know, I know there's not been an application for anything other than this road. But even though we're not going to talk about Kettlesong, we've got to talk about Kettlesong because that's what plays into this. So, I mean, right now I can say if you need a road to York Prep, you can come through here. You know, I'm just saying, you know, I see you need other things, and that's where you're saying DOT says you got to be. Staff saying it's not. There might be another variation. So, what is the grand? I know. Last time the applicant pointed out that this was a Baxter type community, all inclusive kind of. So can somebody just touch on some brief points of that? Is all I'm asking for.
As far as the actual development,
The community. I mean, because you know, y'all say it's a nature-based community, and so tell me a little more about it.
So one way to think about it is if you're to take Baxter Village in Kingsley and Answering Swiss Greenway, mash them up and shrink them down, that's what Kettlesong is. What's ironic about this is I know those trees and I've walked, and when we talk about like with that second crossing for the school stacking, Brian Myrup, who's the executive leader of YPA, he and I have actually walked that land and went back to land design, and these guys have pushed them and said, look, we want the approach to the school, we want people to come through grand, big trees. We are very genuine when we say we're really concerned about the trees out there. And so we've been very thoughtful to be responsive to the land. And I'll give you an example. Look at where the school's positioned. It's actually on a delta between two creeks, and the land cascades down around it. It's honestly some of the highest value land out there. And we decided to put the school on it because it's so compelling, because the school is all going to be about the pedagogical approach includes nature-based learning. And so when you look at that, we've been very thoughtful through this entire design process to say, how do we preserve open green space? How do we preserve these big mature trees? And look, these guys can attest to you. I've been in this conference room in Charlotte and said, why in the heck does that BMP have to be that big? That's going to cost us some big trees. I want kids down in the woods under these big tree canopies. So understand that we're coming from a conservation, nature orientation as we're looking at this design. The reality is those pine trees, anyone who's been on a camp out with Boy Scouts and watched 12 and 13-year-old boys set up a tent and then walk over to them and say, boys, look above you. And because they set up under a mature pine, it's full of what they call widowmakers, right? We're asking for a variance that's very necessary in order to create a place that honestly is going to be very beneficial to the community and is going to be additive to the tree canopy of York County. So this is, ultimately with some development, there have to be trade-offs. And I think if you guys will listen to the arborists and the mitigation plan that we're proposing, it's a good compromise. It's a good trade. We bring high quality development, and we also improve the quality of the tree canopy in that area.
Yeah, I think where we're coming from here, sitting up here, this is I look at this and say, this looks very good, very nice. I like the approach, the conservation. We went through this, how many meetings ago that we went through it and got another variance? And I'm not sure about the tree ordinance says you cannot cut down a grand tree. It's like, how are you going to develop anything if you can't cut a grand tree down? So there is trade-offs, and it's like Reagan was saying, we've got to look at what's the type of trees, how old are they, what are the condition are they? But we're only seeing 1/10 of this development tonight with this tree survey? And we're gonna go through 10 more of these to figure this out?
Well, in order for us to get the utilities that we need, in order to create this tight-knit community, to preserve a lot of open green space, the city of Rock Hill is requiring us to annex. So there is an annexation process that we will go through. This will actually be the hearing that you'll have next week for the Grand Tree variance for the charter school. And this one will be the only two that will come before you guys, because all other work will be done within the city of Rock Hill. And that's by virtue of the city of Rock Hill's policy is if you want utilities, you have to be annexed. And so I unfortunately for you guys, and I appreciate it, you guys are gonna get a lot more of these hearings. You know, we're gonna go off to Rock Hill and work with them, but this new tree ordinance that says a grand tree is 24 inches and you can't take one off the property, you know, forget road frontage variances. You guys are gonna be reviewing grand trees till 2 in the morning. Not to scare you off, but this is just a hair bringer of things that are coming on this.
It's certainly going to be a challenge. I agree with you. You know, we do the developments and run into the same issues that you're running into. But, you know, the challenge for us as a board is you're right. The majority of this project is going to go to Rock Hill because it's going to be annexed. But what we're being asked to look at tonight doesn't even get us to the finish line on the school as far as grand trees. That's the reason I recommended a deferral right out of the gate was we need to see the second half. So it's not 1/10, we're seeing 30%. There's another, you know, significant percentage that I would like to see before I can make a decision.
And we got people arguing over the results of the survey so far.
What it is.
So
We
you're
can certainly
right.
speak to the results of the survey with Greg, but to your point, or to your question on the school, it is a lesser number, but the mitigation plan is gonna be the same at 1-to-1. So whether it's 10 grand trees or 50 grand trees, we're still offering a 1-to-1 mitigation. So, or we will be offering.
Or you will be. You're not offering anything for that
For
as of
the
yet.
roads, we're offering it for 19 or 25 or wherever we end up being. But the same, I can tell you that the mitigation plan for the school will be very similar that we bring to you. So we're not gonna ask for anything different.
Staff said it earlier, once you get City of Rock Hills, grand tree requirements 32?
Yes.
The county just lowered theirs.
Right.
County lowered it February 1st.
But he just sat here and told us, we'll finish that discussion.
I think it's 30.
Excuse me.
That doesn't mean Rock Hill won't follow suit.
But it's less, it's greater than 24.
And I believe Rock Hill's tree replacement mitigation program is less.
Less,
It's not a 1-to-1. It's a lesser percentage. It's not an inch per inch deal.
Yeah.
It's
And
less.
they also don't define pine trees and other softwood trees
They exclude,
as grand trees.
That uncomplicates it a lot.
Yeah.
But the problem
Greg
is,
a
the,
certified arborist, so I would like him to speak.
We've been waiting to hear from you, him all night.
From 57 to what, to 19?
I gotta figure out how this works first. Good evening, board. My name is Greg Bierkamp. I'm with Land Design at 223 North Graham Street, Charlotte, North Carolina. As we kind of all figured out by now, I'm an ISA certified arborist. I think it goes without saying I do care for trees just like the applicant does. So I was asked to go out and assess the trees that were surveyed within the limits of disturbance for the roadway for Indigo and Rattlebush. I was asked to go out to confirm the sizes of the DBH, the diameter at rest height of these trees, and also provide a health assessment. I'd like to start where I think one of the biggest points we need to kind of clarify. There's been concern raised about the quantity going from 56 to 37 down now to 19. And it's the reason for that was has been the measurements being clarified, checked, and in that some trees trees that were, the surveyor marked as 24 inches were not quite 24 inches. They were 21, they were 22, 23. So there was a good amount taken off for that reason. In addition to that, we had also, as Frank had pointed out, made a lot of adjustments to the roadway to work with the land better to avoid more grand trees. So that we get to the number that we're very confident in the amount of grand trees that we're impacting is actually 20. I'm going to get to that in a minute. So I'm going to sit on this. Sorry, how do I go up? Yeah, if you don't mind. Thank you. Appreciate that. If we can sit on that that exhibit for a minute. Yes.
To clarify why he's doing it, so you sent a surveyor out there to do the survey?
Yeah, had the survey done.
So you didn't do the survey?
I did not survey the trees. I went to assess them. I checked the measurements on them. In addition to that, actually, the surveyor had also gone out and kind of checked themselves and found and actually accurately measured the DBHs of a lot of these trees. They found that they were inaccurate in some of those measurements. I also found several that were less than 24 inches. So that's why you're not seeing 56 to 37 trees on this exhibit here.
And to clarify,
I suspect you found some that were different species than what the survey initially labeled as well.
It's confusing too because the surveyors, they do great work, but they're actually pretty good at identifying trees, but there may be a tree here or there that they misidentified. So I was also able to kind of clean that up as well.
and the surveyor works for the applicant, right?
Correct.
What was that, a pine? No, it wasn't.
No,
It's a pawpaw.
it's a third-party surveyor.
Sure.
You work for the applicant,
It's a tree.
Land design.
which is the engineering firm,
Right.
which
Works
is
for
not employed, is only hired by the applicant, right?
Can we get that zoomed out? Sorry. I just want to kind of be able to see everything here. So this actually kind of mirrors, for the most part, what staff had shown. The trees in red are 24-inch and above trees. We actually have, and in a minute I'm going to give a breakdown of species. And there's 20 of those on there, and I'm going to get into that switch from 19 to 20 in a minute. The green, yes, the purple trees in there are trees that, there's 5 of those. And those were trees that were surveyed as 24 inches and above, but in my assessment, I found that they had really, they were either dead, had major structural defects, had pest infestations or disease, that we feel shouldn't be qualified as grand trees based on that. And we're going to get into some pictures of those in a minute. So we are very confident that through kind of several iterations of this and double checking our work and providing a health assessment as well, that the amount of grand trees or trees that are 24 inches and above that would be removed are 20. That does not include, again, the 5 trees that I viewed as in poor condition that should not be qualified as grand trees. Staff had pointed out 6 trees that were could be impacted because of the proximity to the limits of disturbance, and I think what we dispute that in that we are only required to survey grand trees within our limits of disturbance. So, in addition to that, there are several kind of. I mean, the 1/3 rule is a little subjective. I mean, you need to take into account species. ISA also has criteria for setting up tree protection zones that range from 6 times the DBH to up to 18 times the DBH. And they give that window so you can account for species. Some are more tolerant than construction than others. So it's kind of applying that general rule of thumb to those trees that are you know, on paper, close to that, limit of disturbance is, I think we dispute that.
So you just said you took some of those trees out because they were outside of the limits of disturbance, irrespective of whether that you thought that would damage that tree or not? Is that the way I heard it? Because I hope I misheard that terribly.
There were 6 additional to the 25 identified by staff that are outside of the limits of disturbance. So that's why they don't show up on the survey.
So the drip line is outside the limits of disturbance.
The tree, where its location.
The trunk is outside of the drip line.
The tree is outside of the limits of disturbance.
To be clear, that we're shooting to follow what's in the code.
Right, I hear you. I just want to make sure I understood that accurately.
So we, you know, it's like, hey, here's the definition, we're gonna go and try to do it to the letter of the law.
In addition, there was discussion about, there's those 6 trees that are outside the limits of disturbance that staff is concerned about. They also mentioned the 8 trees that are, when we were out on site, that thought was that hadn't been surveyed. When in reality, we believe they have been. When we're not surveyors, so when we're out there in the field, it's you know, it's thickly wooded area. You kind of lose your bearings a little bit. All the trees that have been surveyed are flagged. We believe those 8 trees that in our site visit with staff that those trees had been surveyed, but they're outside the limits of disturbance. So they're just what we had in the field. They weren't showing up because they're outside the limits of disturbance. We were solely looking at trees that were surveyed 24 inches above within the limits of disturbance. So that explains why those 8 trees up, you know, that we identified in the field.
If you want the species list, you can zoom in to the far right of that drawing. There's your 25 species.
Are they on there?
Yeah, so
there's no way I can read that.
Well, I'd be happy to cover it for you. So, like I said,
That's
I
cool.
become very familiar with this area. Of those 20 trees, 14 of them are pines. 3 of them are sweet gums, 2 are poplars, and 1 are oaks. This is a really forested condition, so, and a lot of the trees are close together. So what you typically get in, you know, trees in forested conditions, it's not this, you know, tree that with the branches kind of swooping all the way to the ground. They're pines and poplars and sweet gums that are have low live crown ratios. So that's the percentage of the height of the tree that has live foliage. So, you know, like when you're walking in the woods, it's a telephone pole with a little bit of foliage at the top. So it's not, you know, again, some live oak that's 60 inches in diameter with, you know, branches swooping all over the ground. That typically I think of it when I think of grand trees or heritage trees or champion trees. So let's.
And how many of those were less than 32 inches?
Yeah, so we only had, there was only 3 trees that were 32 inches and above. And those were 2 poplars and a pine. The 5 trees that we identified as in poor condition, those were 3 pines, 1 maple, 1 poplar. And then, as we've already heard, the reasoning for the alignment of the road, another reason that kind of supports the position, you know, if we're kind of trying to stay away from the wetland area where you get a lot more hardwoods, bottomland hardwoods. So we would rather, you know, if grand trees are gonna be in the way, we'd rather kind of come up where there's pines that are, you know, maybe no more than 40 years old, and stay away from the more desirable trees. We understand the ordinance that says a pine can be a grand tree or a hardwood can be a grand tree, but we would argue that we're staying out of the way of more desirable, larger trees. These a lot greater down in the wetland area, tend to get more 30-inch or 32 inch above trees. Again, a lot more, pretty much all hardwoods in there. There's no pines down that way. So.
I want to say, Greg is an expert, and he can torture you for another hour on some details. But we can also move on to talk about our tree mitigation program.
Yes.
So would you guys like to go through excruciating detail tree by tree, or would you like to learn about the mitigation program that we're planning for?
How about let's see a few photographs and move
Sure,
on?
yeah, just this is one to give you an idea of the existing condition out there. I'm gonna flip through these quick. This was a 40-inch poplar, so on paper it's huge, but you get out there and there's cavities. I think that actually very surprised it hasn't fallen over yet. But there's a cavity that you can see all the way through it. That's the other side of it. This is a pine. These are those 5 trees that I assessed as in poor health. Maybe lightning damage, but there's a longitudinal wound or area decay on this pine. Again, you can see the telephone pole kind of nature of this pine. And most of the other pines are like that, maybe just without the wound. This is hard to see, but there's a wound at the base of this tree. Right here, this is a root to it that's been it's been damaged, and then in addition to that, the same tree, there's exit wound holes from a larva of bark beetle, whether it's Ips or southern pine beetle.
I thought those were standard in pine trees.
They can be. A maple, that branch must have torn out. It's got a large area decay in it. It's also leaning significantly. It's over 24 inches. It's hard for me to to think of that as a grand tree. This is the tree. This is one of the trees that the staff that's actually that's very close to the limits of disturbance, and it has a lot of issues as well. It has some structural issues. That's a sign of potential root rot or a cavity within the base of that tree. But with all that said, I think a means to a resolution is the mitigation plan that's put forward. So City of Rock Hill has been talked about their heritage tree programs, 32 inches and above. They have a mitigation program. Many other jurisdictions have grant tree ordinances, but they have a mitigation program that goes along with it. That if grant trees are going to be removed, then they do allow approval that to be mitigated. Many are 1-to-1. Rock Hill was 1 to 0.56 inches. But the important piece here is, with all those pines that we would be removing, we would be coming back in with an increased diversity of tree species, all native to eastern North America, that would be 693 inches based on those 20 trees being removed, and we'd be replacing 1-to-1, 695.5 inches of trees. And I think, again, to me, the important thing here is the species diversity. We may be losing 20 trees, 14 of those pines, which are arguably, going to die soon. Bark beetle, not as desirable, and we're coming back in with really desirable trees and a wide range of species to increase the diversity here. So, and I think it's really kind of in line with what Craig talked about, kind of the vision of Kettle Song. We do care about trees, and we are trying to, be environmentally conscious and really bring trees onto the site. So.
But before you go, I'm gonna ask one more question, and hopefully I won't have any more. So right now, at some point we're gonna have to make a motion, and it's a motion to approve, a motion to deny, a motion to defer, whatever that. So if I was, and right now in our packet, we would be making a motion to approve a number of trees that is inconsistent with what you believe you need to remove. So if I was to make a motion to approve, I would need to make a motion to approve 1 24-inch oak, 8 pines, or whatever those 9 trees or whatever the number is. I have a hard time with numbers, even though I'm an engineer. I have to put that together in my motion and then say that those trees are going to be replaced on a 1 inch or an inch per inch caliper replacement. I mean, in my head, replacing a 20-inch loblolly with 20 inches of new willow oaks and providing diversity is not a bad deal if we're truly only impacting one nice oak tree. How do I make that motion if I so desired? And right now I don't have that information, so go ahead. That's where I'm going.
I want to speak to that quickly, so if staff could zoom in to the species list, just to reiterate here. So we are, as the applicant, are very confident that we have identified 20 grand trees within the limits of disturbance. The 5, you can see the list. If you scroll up just a little bit, you'll see the 5 below that I believe staff and arborists are in agreement that those are diseased and or dead. Go the other way, please.
Other way. Oh,
Up, so I can see the list.
No,
down.
other-
Go
opposite.
down then.
Go down.
The other up.
So
So those are disease, they wouldn't be part of a motion.
we would, it's our contention, those 5 would, since staff is in agreement that they're diseased and dead, so we're really talking about the 20 trees within the limits of disturbance, okay? Now, that does exclude the 6, in addition, that they feel are close enough to the limits of disturbance that they may be damaged, nor does it include the 8 that are outside the limits of disturbance that they feel were not surveyed. We think they were, they're just outside the limits of disturbance. So again, we're talking about the 20 that we all agree are above 24 inches and within the limits of disturbance, and that we are asking for removal. Of those 20, I think if you count them, 15 are pine. 1, 2, 3, 4, 5, right? 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. The top one is a pine. So I think there's 15 out of 20 is pine. 2 sweet gums, 2 poplars, and a 29-inch oak. That's essentially what we're talking about. And we're offering to mitigate 15 pine trees at a 1-to-1, in addition to those 5.
How many acres is your total disturbance?
4.5, 4.6 acres for the roads. And if we were to consider other access points off of Mount Holly, as staff showed in the very first aerial photograph, those are all pines and hardwoods along Mount Holly anyway. So you're still gonna hit hardwood or grand trees. So at some point, we've got to deal with the tree issue. And if we access it, as you said, we continue the roundabout straight, we don't get the 2,000-foot required stacking for the school in its current location. So then we're redesigning the entire development. And we don't have time to do that for 23 opening. That's just when the schools get open.
I agree with you. I mean, I think we're gonna run into the tree issue wherever we go.
You're gonna
I'm
be
just
fighting trees.
trying to figure out, staff showed me 10 pictures and y'all are showing 5 and y'all are saying 21 and staff saying 39 and he's saying 19, you're saying, I mean, it's just,
Again, the
it's a
difference
lot.
is the 14 that they're saying outside the limits of disturbance. That's the difference. Whether it's 19 or 20, we agreed to the 5 disease, so it's 20. Let's say it's 20, the other 14 are outside the limits of disturbance.
That's why we would have to.
About the drip line. That's the difference.
So are we making a, I mean,
we could control.
We still haven't heard from
Yeah.
no, I'm just saying, I mean, when it comes to motion, are we making a motion in inches? Are we making a motion in number 8 tree? I mean, it's just,
Yeah.
it's a lot.
One thing I wanted to add is those 5 disease trees are actually part of the mitigation. We are actually accounting for those 5 disease trees.
But they're all.
We're all going to mitigate those.
Since we're crowding the mic here, so to conclude, because I know we need to move on. My recommendation is that considering our tree mitigation program covers not only the 20 trees that we know, but it also includes the 5 trees that we both agreed are dead. So we're going above and beyond. So you have an extra 5 trees in there that if we're doing it strictly based on grand trees, we're saying we're actually going to do more than that. So my proposal to you this evening and my request is that you guys would give us the variance with the approval to remove up to 25 grand trees. Because any other thing where we try to specify specific numbers or whatnot, it means we're gonna be coming right back in here. And I think we've done so much work on the surveys and had revisit, recertified, that we can be confident. It was CES Engineering that did the survey for us. By professional standards, they're going to do a good job on that. The request for a third party to go out and do yet another survey, well, if the county doesn't pay for it, I guess I get to pay for it. And at that point, how's that any better than the survey that we've gotten done, right? So we have got a good survey. We have a good understanding. And the decision this evening is whether or not we're going to allow a great mitigation program to be implemented to remove trees that need to come down in order to create a great community and in order to support and enable the construction of a great school. And I hope that you will consider that this evening. We've been very transparent. We've been trying to provide as much detail as possible, and I hope that you'll consider our variance request reasonable and support it. Thank you.
Thank you. Do we have anybody to speak in favor of the application?
My name is Gladys Robinson. I live at 2085 Cavendale Drive, Rock Hill, South Carolina. My family owns the land that comes to the point where Neely's Creek Road, 901, and Harmony Road come together. And I've sat through this entire evening and I'm trying to figure out why am I here. How do I connect with all of this? Because from what I've seen, all the action is taking place in Pine Top. And my family's land is off Neely's Creek Road. So can somebody provide some clarification as to how I fit into the whole scheme of this?
I believe you're just gonna be a neighbor.
Neighbor's gonna be what?
I believe that you're just a neighbor. I think county sends out notifications.
I know you send out notices, but I guess I know that within the city is so many feet, a certain distance. So I gather, although a road all the way over is within the parameters of whatever the area is.
Yes, ma'am.
Okay, I just want to be sure so that the next time I get one of these cute little yellow sheet forms,
We do appreciate
I
you
can
coming
make
to
an
visit.
informed decision about whether I will meet with all of you. Thank you so much.
Thank you.
Oh, late night.
Yes.
Good evening, Dan Ballou, 331 East Main Street. I'm going to be very quick because unfortunately y'all have to hear from me next time with YPA. I represent YPA, who is really the point of this access road is primarily access to the school that's going to be built. And we have just, I believe today or yesterday, submitted a packet for our own tree preservation plan, which will be coming up on your next agenda. Obviously, we are very concerned about safety, access, road safety, and the environmental aspect that I think has been conveyed to you, and so we certainly are supportive of this. The amendment of this tree ordinance, and this thing has been, the Grand Tree Ordinance has been around for years and years, but I venture to say you haven't had to deal with the kind of scale that this application presents, because now when you ratchet it down to 24, you're going to capture a lot more trees. And I think the point is well made. The definition of grand tree actually is not exactly 24 inches of caliper width. It says it can be determined by caliper width, but it talks about trees of significance and trees of cultural significance and environmental significance. And that's what I think is the intent of this ordinance, is to protect the trees we want to protect. And the ones that are gonna die are the ones that are timber, not so much. We don't have to worry as much about that. And that's why staff is empowered to make these decisions. My hope is that ultimately staff will be empowered to be able to make these decisions on an administrative level and then come to y'all with the real difficult issues. But unfortunately, this is new, and I get that, and we're in front of you on kind of a square peg and a round hole process under a variance that
I still think even though the variance standard wasn't designed for this particular application, that we meet that requirement. And even though the staff has recommended that we haven't, the bottom line is that the configuration of this site, the environmental sensitivity of the site, the access issues to this site are unique, and they are exceptional, and they do meet the requirements for a variance. And so we would simply ask you grant the variance as to the trees that are listed on this site plan, and I'll see you next month.
All right, do we have anybody else speak in favor? Do we have anybody to speak against?
Real quick, I will say that there was a member of the public that approached me earlier. Unfortunately, he had to go. He sent an email to y'all, and he just wanted me to let you know that he was in support. He's sorry that he had to go, or else he would be here. Robert Riles at 103 Pondview Lane in Fort Mill.
Thank you.
Good evening. My name is Lindsey Walker. I reside at 1263 Birkeland Drive in Rock Hill. I am currently the chair of the York County Forever Commission, the conservation agency for York County. I compliment, the owners of Yellowstone Farm, our development, for their publicly expressing their effort to preserve open space in York County. However, I do not support the variance request to cut down the grand trees on the property for several reasons. First of all, the developer has said they are stewards of the land. Yet, depending on the plan submitted, they want to remove, it's hard to even keep up the numbers, been going down tonight, guideline. But I think the most reliable source I have is here from the county is 39 trees.
Correct.
And that's based upon an initial phase of a 550-acre development. So we can't even begin to count the number of grand trees that probably have to come down before this development is over. Also, the request will set a dangerous and destructive precedent for subsequent phases of the project and could apply to similar projects in the future. Also, the requested number of grand trees to be removed would seem excessive in relation to the scope and size of the project being proposed. Lastly, there's no alternative plan has been proposed to relocate the new road design. It would appear that the location of the grand trees in question can be avoided with a new road layout. And I think that was kind of pointed out earlier. As one of the fastest growing counties in the nation, I'm grateful to York County leadership for approving ordinances this past February to provide forward-thinking guidelines for real estate development. I refer particularly to YC zoning codes, conservation subdivision sections 155.499, cluster subdivisions sections 154.074 to 154.078, and also residential development standards sections 155.532 through 155.39 regarding grand trees. These ordinances are designed to maximize and complement the county's objective to preserve open space. They follow the astute open space zoning concept introduced by Randall Arendt. The article I've handed out is a synopsis of his book called Rural by Design. Arendt's exemplary concept seems to have turned traditional real estate development upside down. He stressed that having open space and developments are opportunities, not liabilities, because open space can provide the potential for a higher return on investment for landowners and developers. I ascertained that conservation adds value. While I was doing extensive research to justify the purchase of Riverbend Park, numerous empirical articles and studies showed that the properties within a half a mile of green space increased in value a minimum of 20% and consistently outperform other properties not adjacent to green space. People do pay a premium for green space. Studies confirmed that the added value of green space can more than offset the added infrastructure costs for a housing project. YC's open space design for conservation in cluster subdivisions to substantially reduce the development's infrastructure costs for roads, water, sewer, and utilities. Importantly, there's added economic benefit. Green space can be replaced in a conservation easement that allows property owners a 50% tax write-off against adjusted gross income over 15 years. A proven example is Ann Springs Close Greenways, whose conservation easement enabled tax write-off against adjusted gross income for Baxter Village. In conclusion, based on the above, I question the need for variance requests to remove trees including oaks, poplars, natural fine forests, etc. By the way, Reagan, you were talking about the age of trees. I handed you an article, talking about the actual average growth of trees. And based on the average growth of trees, they grow approximately, it takes 5 years for it to grow an inch in diameter. And that includes pine trees, based on the article or study I've been able to pull out. And so in order for a tree, and then also based on the International Society of Arboriculture, Formula, and Purdue University's report indicated it would take 5 years for most trees, including forest pines, to grow to 1 inch in diameter. Hence, a 24-inch tree in diameter is at least 120 years old, and has been growing since William McKinley was president of the United States in 1900.
Not loblollies, Mr. Lindsay. Only longleafs live to be 120.
Yeah,
Sorry.
no, that's a different story because
These are loblollies on that farm.
We're talking about there. And also you got, that oak tree you talked about, that was probably around when Abraham Lincoln was president. And so those trees are very old. What I suggest, is one that, reroute the road instead of a sharp left at the traffic circle of York Preparatory Academy, continue straight to access to school, using a less environmentally destructive route. The second thing I suggest is you follow YC's guidelines for conservation subdivisions and cluster subdivisions to maximize return on investment through the use of open space. This will be very beneficial to the developer. This may entail additional expense and delay construction and opening of York Preparatory Academy. However, the suggested alternative of open space to preserved forest could potentially offer a higher return on investment. At the same time, it can allow for conservation easement tax write-off against adjusted gross income, wetland mitigation credits, and possibly carbon credits for the forests that will be remaining. Let me conclude by mentioning that it takes a minimum of 20 years for white oak to grow a single acorn. From a tiny acorn, mighty oaks grow, but only if we let them. Thank you for your thoughtful consideration and to preserve open space and our natural resources. We all benefit. We all want continued growth for York County, but we also want responsible growth to benefit everyone, not a select few, for generations to come. Thank you for your time. Do I have any questions?
Thank you. Someone else want to speak against the application? Seeing none, any further comments from the applicant?
I would just like to say that we're actually very familiar with the value of open space. And I would dare say that there's probably, other than maybe the Springs family, not a developer in York County who's local to York County who's putting his own money up to do this development that's more interested in green space and conservation. But the reality is we have to be able to build a road. We have to be able to bring utilities in there. You have to be able to bring basic services. And the idea that we're going to find a different route, I mean, come on, you guys remember the pictures that Peter showed at the beginning? The place is a forest, right? But it's a pine stand. And so, yeah, it's kind of easy for the county to say, oh, why don't you go spend another $100,000 and try to figure out if there are other paths out there? Well, guess what? We've already spent $500,000 to very competent, great engineers who've been given directive to be environmentally sensitive to the property, who've worked with Office of School Facilities, South Carolina Department of Transportation, with the SCDOT, and with York County Traffic. We have done that research. And so the idea that, golly, Craig, go away and spend more time and money because maybe, and to be clear, they haven't provided any suggestions. They just said, we think there may be potentially another road out there. No, we have done the homework. We have been thoughtful, we've been considerate, and we've been diligent. And our request to you is to grant us a variance to remove those grand trees to allow this project to move forward. We will replace it with higher quality trees that will contribute to the tree canopy and add value to the community in a way that preserving these 20 trees will not do. Thank you.
One question, Craig. I know you probably told us. When will it be annexed?
So the current timeline on the annexation, the soonest it could probably be annexed would be December. It could be annexed as late as March of next year.
And when do you want to start breaking ground to get the schedule the way so you can have the school open?
So currently, we need to be breaking ground. Be breaking ground in September. We're building these roads with the county, right? So we've got to get these things going, but we're also walking this wire of coordinating with the city and what they want to adopt, and also meeting the county requirements. So that's the reason there's some urgency to get this approved so that we can move forward.
When was this? I know that the different plans you've got. I mean, they changed the ordinance in February. When did you start doing this? Because I know you didn't get it together from February to March, so that's why I'm asking. All of it. When did you start with your plan?
2018, we identified that the Pine Top Golf Course was considered as an acquisition by someone like D.R. Horton that wanted to put 1,000 starter homes in there, and so I swooped in and bought the land. 2020, another property owner got offered land, and I preempted that, and I bought that land. And so I would say in earnest, probably in the 2020 period, and land design went to work really hard, developing a conceptual plan. Let me just emphasize that color plan that you see up there is conceptual. Things, you're shaking your head like it's like a lot of things can change. The only thing that we can really speak to in concrete detail today is what's being presented to you here today.
D.R. Horton was 1,000 homes and you're 1,200.
No, 291.
Oh, he's down to 291 now.
Yeah, I mean, it's.
All I do goes by what's said in the papers. Things don't ever seem to stay the same.
And it's
Like number of trees.
Like numbers of trees.
Jeez.
And so
I do have one more question for somebody. Whoever did this tree survey. There's you did this?
That's that is my, yes, that's the list I put together when I went out in the field. And that list includes the school property too, that's why it's 73.
Okay.
Yeah, so we actually,
Well, I counted up the yeses on here, and which no numbers have made sense all day. So I mean, I don't know why I was thinking that one too. But gotcha.
that list was put on the location.
Okay.
Can you do another full screen on this figure that we're looking at?
Jack, I was with land design, I worked with Frank and Greg here, I'm a landscape architect. I used to work with Peter at land design also, 223 North Graham Street, Charlotte, North Carolina. I've probably worked on this for seemingly over a year, maybe, once Nick got in touch with my boss and probably went through 10 iterations of master plans and putting in a CAD. Initially, to get the school built, we just wanted to submit the plat roads. So we talked to Amanda Kay and Jeff Kirchner, we just showed the roads. So we sent a plan in with the roads because we needed road frontage. So this was going to be our public road access for the school. So that they got in, we're okay with the road, but then when they got to Peter and planning, they said, well, we need more context because we can't just approve roads. And so that's when the school showed up. And they said, well, we need more context in the schools, and we dropped in a whole master plan. And so that's kind of we start with the road limits disturbance, and then we go to the YPA. And then when you see the whole picture, I think everybody kind of looks back and is like, now you got this massive development of trees. So I'm fairly confident with the numbers that we have, and you can even see the number of green trees, the location of the green trees in comparison to YPA Academy. There's significantly less trees, and I know, based on Greg reported, at least 3 or 4 of those green trees up in the parking lot on the left side are dead. So just want to say, and as part of the mitigation process, so we're mitigating 1-for-1 for the trees we're moving. We also, initially, we talked to Amanda Kane and Peter, and we said, well, maybe we can do street trees for New Indigo Street and Rattlebrush Road. So we've got street trees, 4-inch caliper, 40 feet on center, and Pete came back and said, York County does not allow street trees. So Amanda said, yeah, you can't do street trees. So the plan is, if we get annexed into Rock Hill, we'll put those willow oaks or oaks, whatever they are, the hardwoods, back as street trees. So that road section is set up now with the wider planting strip to accept those trees, and they'll be in the Rock Hill, the 8-foot planting strip. So it's technically, it's a wider, right now it's a 16-foot planting strip. It's wider than York County and Amanda King would approve, but since she saw our full vision or build out of the street, she let us show that. So the mitigation plan actually has the trees shown on it. I think we just forgot to talk about that. But that mitigation number for the street tree is not included in the grand tree removal. That's far and above the additional number, because York County doesn't require the street trees, but we were willing to show them on there. So even more trees, probably another 200 trees in addition to the ones we're mitigating. So you're talking maybe 300-400 trees that would be ultimately put back on this site. And there was a comment from staff about, well, if you're taking these grand trees out off the road in the limits of disturbance, you need to put them back on within that limits of disturbance. Well, if you saw the aerial, it's all trees, so you can't just put we can't just put 4-inch oak back in the forest, and it's just not gonna live. So where we put them over on the left side where the park was, that's where the Pine Tuck Golf Course opens up. So that's actually open space right now where the trees would live and thrive.
Thank you. I would make a motion to defer until the August meeting. And
Sorry, I second that.
And the reason I say that is that I think we would like to see more in the other portion of this road development. But they do need to get moving on it if they want to do it, for schedule purposes. I think we need to look at, as members of the board, look into the tree ordinance, consider looking at Rock Hill's ordinance, and seeing what's going to be impacted the developers when they get annexed. And I think we've got a lot of material here. We need to consider what's the important trees. I mean, is a loblolly pine, should we be considering a loblolly pine as a grand tree or not? And we got to consider development. If we can't remove a grand tree, we can't develop.
No. That's right.
And to take that in consideration in this whole thing.
Trees 24 inches. I mean, that's
Right.
No.
Yeah.
You're not going to be able to do a project anywhere where that you're not going to have to take out a grand tree or 10 grand trees or whatever the case may be to do development. In this instance, it would be, a lot, the information that's presented and taking out one oak, I don't have a bunch of heartburn with that, right? For a development of this magnitude. I wish that the development group and staff were a little closer on the same page as to, how many they are, what are there, I think there needs to be a little bit more discussion there. That's, so a deferral, I think, is probably appropriate for that reason as well.
Well, you got staff saying this and no proof. We've got these guys showing us a lot of stuff, and I think you can tell by my attitude, I agree with you a lot, but no proof. Nothing's been validated, nothing's been stamped. And I don't agree with it. I served on that tree ordinance committee when it was in the 90s when we came up with the tree ordinance. I was put on there to minimize its impact. I was put on there as an beginner. okay? And we fought the 24 versus 32, and we settled on 32. To be honest with y'all, I didn't know they'd lowered the damn thing to 24. That's insane.
Yeah, it's
That
tough.
That farm was part of my family, and a lot of land in there. And I hunted those fields in my 20s where the pines are now. Longleaf pines matured 120 years. Loblollies die at 40 to 45. It was planted with loblollies by Bowaters, and they were doing CRP program. Bobby planted all that stuff. I know, because I know that property. And it's all sandy land to boot. And that's why those pines didn't get very big, because it was real poor sandy land. They've been there 40 years. And so a lot of them they're gonna start dying. And so, but along the creeks and the banks and the wetlands areas, the oaks were never cut. We never cut them on my place either. And when you take the pines out, you do have a pretty hardwood beard on that place. I know that property. And so I want to vote with these guys to cut these dang pine trees. They're gonna die anyway. If they're gonna do mitigation, I think it's a good thing. But at the same time, I'm not 100% sure. You gotta make us 100% sure, guys, so we feel comfortable. As Lindsay brings up a good point, you know, we've gotta stop. If we're gonna preserve these trees in the county, you gotta start somewhere. You gotta start doing it. The reason for the 24-inch drop, y'all, from what I've heard politically or whatever, is that's to stop the old clear cut it and develop it. That's what that's all